conviction, appellant has been in custody for more than 10 years.
I want to mention in item number 33, it was listed because I am on last date I am already mentioned to be.
The writ application was remanded back by the Honorable Supreme Court, and after it was remanded, you will also be extensively heard the matter and posted to 24th February. But thereafter,
Give it.
Criminal appeal. In custody more than 8 years ago.
Supplementary list, item number 1.
number 1, I pray for some time. It might be taken up after. Here, we have opposite party 1 and 2 are MCL.
So how many adjournments you will take?
That's on the last of it.
And we have mentioned in the order dated 17/3/25 that we are not inclined to interfere with this one. So, and you cited some decisions, also 2 decisions.
That decision I have submitted and provided to the current state council.
Yes.
Thereafter, you have taken date.
Yes, sir.
Last time.
Then thereafter, 1 date minute I have taken and adjourned.
What is your name?
Gaurav, I have taken. Last of it.
You are appearing for?
Petitioner.
Mr. Das, VP Das.
On behalf of, yes.
Last time you appeared.
Yes.
Mr. Gaurav Mohanty.
That's
Mr. Gaurav Mohanty, Land Counsel for the petitioner, seeks for an adjournment after summer vacation. Put up this matter. The urgent permit.
That's fine. Lordship, there is not opposite party number 1 and 2 are MCL. Lordship, that I can serve the copy on my learned senior. I can serve the copy of.
You have to satisfy. We have already expressed our view. You don't have a
We are
case.
not issuing any notice till now.
Yes.
Yes.
Item 2.
Please, Your Lordship. Item 2 will kind of a glance to order dated 24th January. By the director, this government council to take instruction in respect of the payment of award amount under section 28A of the land acquisition act.
Yes.
Lordship, after passing the order, taking up the district magistrate has written a letter that he has asked the zonal officer Ringleton to Your Lordship may grant some more time.
No, we'll take up this matter in Lok Adalatin. The award has been passed in his favor. 28 application has been allowed. You are to, and that order was passed. You see on when that order was passed.
It was passed on 31st January 2023. The journal office has requested to release the amount, my lord.
On 29 March, the collector has written the letter to journal officer Rangali Dam project for compliance of the order. Your Lordship may.
In 2014, my lord.
It will be taken on 14. I will take
That
it.
It's on 14 and you.
On
What
14.
is this?
I just want to.
The-
I just pray for 3 to 4 minutes.
matter be placed in the next Lok Adalat, scheduled to be held on 10th of May 2025. Which date the wish to appear. calculation sheet was produced before the director, so and so, tentative calculation, on which day the director R&R from additional secretary to the government of Odisha Resources, Odisha Bhubaneswar, shall appear before the concerned court through virtual mode. And apprise about the sanction of the decretal amount as per the who has passed that order?
By the zonal officer, Rengali Dam project, they over.
No, that is based on that LA case, no?
LA case number, my lord. LA case.
LA case पर अपन 28 application
28
file कले
हाँ.
enhancement अच्छा जो से amount है सी 26/2014
Ma'am, hello.
जा लिखा है से order टा कोड गला
ये 7/8/1999
that is initial order तापरे उची 28 रे enhancement हला that is on 26/2014
14.
से order टा कहीं जरा कोड order लिखा है ची 20
para 6
That is on 27/11/2014, my lord, page 11.
para 6 of the writ petition.
সেটা আমি লিখিত order
They have passed an order enhancing the award
right
by order dated 31/3/2020.
कौन लिखले as per the award dated for them to 26/2014, while considering the application under section 21(8)(a) of the Land Acquisition Act. Hello? Yes. This free copy of the order be handed over to the Land Council for the state. You remain present on that day.
Yes,
in
ma'am.
Lok Adalat.
These are the matters, no adjudication is required.
Yes, ma'am.
Because of the letharginess of the
Only to
bureaucrats, this matter.
The award amount is some 2,000 something, but interest is our 2 lakhs.
Award amount is first award amount is 7/8/1999.
99.
Enhancement order was passed in 26/2014, and now after almost 11 years have passed. Yes,
Next also similar. my lord.
20 lakh interest rate.
same. See appear करियो ना? हाँ. ताकि देखिए लखनऊ को से same appear करियो.
Make sure that it is complied.
Yes, sir. You see, making speeches is very easy, but implementation is necessary. Yes.
Item 4.
I come for here also, my lords, despite the decree passed by the civil court, lords, I am unable to get the awarded amount. Lords, 4 times has been granted to the state to take instruction. my lord.
Same story.
Amount is in deposit also. Since 2014.
It is a,
Who is to appear?
instruction has come and it has already been deposited in civil court.
Yes, that is there. Already
So that has to be returned from the civil court fund. Lordship on 2/4/2025, we have taken instruction. Ma'am, I'm just.
The person.
Aye.
deposited since 2011. That is there in the order itself. my lord. Page 19, your lordship.
It has been withdrawn from the LA office and deposited in civil court.
Just move application for civil. application is to be disbursed.
My lords, I have filed an application before the, my lords, civil.
When
judge.
filed?
My lords, she expressed, the honorable civil judge has, the honorable civil judge has expressed that since I have already passed the judgment, I became compass officer, I cannot do anything. Therefore, I have
No.
approached.
We
I
are
have
not
approached-
execution.
No, your lordship, kindly see, I have approached the register as well as the Nazir, my lords. That
How we are directing that is?
My lords.
The,
Answer, please, your lordship, kindly.
already we are directing. The Learning, Council for the State has produced the letter number 609/LA/KSD/25 dated 2/4/2025 of the Land Acquisition Officer Khurda, wherein it is mentioned that
Even on the judgment, page 19.
Please.
I'm full.
that certain land of the petitioner has been acquired for the construction of 100-feet master plan road in village Yagamara, by LA case number 14/2008 of LAO Khurda. And an amount of rupees 64,05,511 was awarded towards compensation. And due to apportionment issue, compensation amount could not be disbursed to the land loser. Subsequently, the matter was referred to civil court under section 30 of the Land Acquisition Act 1894 for adjudication, and the compensation amount of rupees 64,05,511 to that effect was deposited by the LAO Khurda to Allahabad Bank, bracketed Khurda branch, by check number 997498 dated 26/11/2011 before the civil court. Stop. The Civil and Civil Judge Senior Division Bhubaneswar in judgment dated 18/4/2014 has been pleased to allow LMS case number 18 in holding therein that the petitioner is entitled for compensation in respect of our purchased land measuring acre sum 040 decimal. And that on verification of the cash book register and Allahabad Bank passbook in connection with the aforesaid matter, it was found that an amount of rupees 64,05,511 has already been withdrawn from the account of LAO Khurda on 22/5/2012, deposited in the account of civil court. And this fact has also been intimated to the Civil Judge Senior Division Bhubaneswar by letter number 298 dated 2/3/2024, L number 661 dated 25/6/2024, which are also annexed to the letter of the Land Acquisition Officer Khurda presented before us. In view of such state of affair, there can be no difficulty on the part of the Land and Civil Judge Senior Division, Bhubaneswar, to release the amount to which the petitioner is entitled to get as compensation for acquisition of his land. Stop. Let the petitioner appear in the next Lok Adalat, that which is scheduled to be held on 10th May 2025 before the Land and Civil Judge Senior Division, Bhubaneswar, in the aforesaid case, and necessary order and payment shall be made in his favor on that very day. Stop. Copy of the order be communicated by the registered judicial to the concerned court forthwith, along with the letter dated 2/4/2025 and the connected documents which are produced before us today. Accordingly, the writ petition is disposed of.
That one copy maybe.
Yes,
That is the only copy available.
there was not a copy either.
So this document dated 18/4/2024. You have to detected 14 days.
Item 5.
The petitioner challenging the order dated 2/1/2025 had annexure 9 passed in case number 14 of 2025. I have kindly see wherein the learned ADM rejected the limitation petition. My lord, I mean, 16 acre of forest land illegally settled in favor of the opposite party number 5. I had annexed it.
What is your prayer?
My prayer is to ask the order, limitation order.
Which order?
My lord, at annexure 9, can you see page 60,
63.
64.
63.
Extract of the order dated
2/1/25.
My lord, 16 acre of forest land settled in favor of the opposite party number 5 in OEA case number 784 of 97. Contrary to the provisions of this circular. Thereafter,
So the petition, there was a delay of 6,540 days.
my lord,
That was the reason for which your
my lord.
this case was not entertained. So it was not decided on merit, on the ground of limitation. So which are the provision of that, which act is this? The order jo pass is additional district magistrate Venkanar, under which act it has been passed? Let us see that provision.
My lord. My lord, kindly see, it was settled on as per the provisions of circular number 7677.
No,
dated-
come to that
Provision.
provision. Also circular, let us see the relevant sections act. This order which was passed 2/1/2025, why it had gone to the collector?
My lord. My lord, kindly see. At the an area of 16 acre land was settled.
You are not, we are asking you which provision, under which provision you preferred that appeal before the collector.
My lord. As per the,
Tell us the
Yeah.
appeal provision.
my lord.
Where is your,
My lord, as per the circular, land was settled, there is appeal provision.
where is
My lord, kindly see,
the act Where is the
Oh,
act?
yeah,
Where
Orissa
is,
State
where is your
Abolition Act.
petition? Let us see your petition,
My lord.
which was
My
filed
lord,
before
in the
the.
circular, it has been.
Why are you going to the circular? We are asking you a plain and simple question. Which petition you filed before the collector, additional district magistrate for adjudication? Where is that petition?
Your OA appeal number 17 of 2021 filed under which provisions of law? That's the question.
The circular provides for appeal provision.
60.
Where is your petition of appeal?
My lord, annexure 6, my lord, annexure 6. Sorry, my lord. Annexure, yes. Annexure 5.
Annexure 5.
Initially filed OA appeal number 2 of 2013. Thereafter, again filed. My lord, kindly say annexure 6. OA appeal number at page 42.
40.
Under which provision you filed that appeal?
My lord, the circular prescribes for appeal within 30 days.
Against which order you filed the appeal?
My lord, we filed the order of settlement passed in Bebandobasta case number 784 by 97.
Where is that order?
My lord, kindly see annexure.
Where is that order dated 15/3/2003?
My lord, kindly see at annexure 3. Annexure 3, page 26.
No. In that appeal memo,
My lord,
you have mentioned that you are preferring the appeal against the order dated 15/3/2000, page number 44 of the brief. 15/3/2003 additional तहसीलदार ढेंकानाल जो ऑर्डर टा पास कर ले बे बंदोबस्त केस नंबर 764 of Swansore say against the appeal.
appeal filed.
Hello, right now.
My lord,
So this appeal was preferred under which provision of the OER?
my lord, that was described that the land was settled on the basis of the circular. And in that circular, there is it provides for appeal provision. My lord, kindly see.
In the act, there is no appeal provision before the collector.
No, before the ADM. My lord,
Before the
prescribes-
ADM.
Before the ADM.
Which is that provision in the act?
My lord, Orissa State My lord, in case of rejection of claim of any person, a 30 days time for appeal to the circular should be allowed.
This order which was passed by the additional Tahsildar Dhenkanar on 15/3/2003.
My lord,
Where is that order? 15/3/2000.
my lord, kindly see annexure 3. Annexure 3 is 26 to 29.
15/3/2003 kind order ta.
My lord, here is page 27, kindly see. Yes or not? Yeah.
27.
My lord.
On that day, it was adjourned to 15/3/2023.
My lord.
Pronounce the order in the open court. 15/3/2003. It is pronounced the order in the open court of so and so. So RK to effect necessary correction in the R1 and issue intimation slip to the RI so and so. So this order which was passed by the additional Tahsildar on that 15/3,
My lord.
it is under which provision
My lord,
against which you prefer the appeal?
under the provisions of OE Act and
Who section? Who section?
6, 7. Section 567.
Five, six,
Basing on the
seven.
circular-
Come to that 567.
Right. Members. Members, can you see a circular was issued? 567. And a circular dated 6 December 2000, wherein it was directed to settle the Bebondost land.
Where is that?
Madam, that Madam, page 179 of
169.
179. Rent settlement on the land recorded in Bebondost status in the record of rights. But
That
the
is
last
180
portion.
rent settlement, yes.
Madam,
What is stated there?
it has been brought to the, I'm reading page 182. It has been brought to the notice of government that in spite of issue of the above mentioned guidelines, vast extent of vested land still continues in Bebondost status in several districts of this state, particularly in undivided Cuttack, Puri and Baleshwar district. The last bunch of subsisting estate vested with the government on 18/3/1974. That is more than 25 years backward. Therefore, it is a matter of concern that many such holdings still continues to in inadequate status and people continue to possess the land without paying any rent for the same, considering the gravity of the matter and loss of revenue. Government desires that a special drive for a period of 1 year should be taken up with effect from the date of issue of the circular to wipe out the Bebondost status from the record of rights. For this purpose, in suppression of all the previous circulars, including the one cited under reference on the subject, the following guidelines are given which should be followed meticulously. My lord, in that circular, in the A, it was ex-ruler, land held that service tenure under the ex-ruler of the erstwhile princely states. And in C, homestead land of ex-intermediaries and lands in.
Where are you reading?
My lord, in that circular at page 181.
Paragraph 1.
Paragraph, last paragraph, capital A.
C, capital C.
C.
Capital C.
183.
183.
183.
Yes.
My lord. Homestead land or of ex-intermediaries and lands in khas possession of the ex-intermediaries. Here the case is land under the position of recorded in the position of ex-landlord. But the land was settled in name of a stranger, his daughter-in-law.
Yes.
What happened? What is the
My
circular?
lord, in the appeal, my lord, kindly see page 69.
No, what this state?
After settlement, appeal was preferred.
Where is the appeal provision in this circular?
My lord.
Because so far as appeal provision in the OEA Act are concerned, we find that section 9 is the one such provision.
32. In the circular, where is the provision you are showing?
My lord, page 87 in case of
187.
in 187.
Yes.
It tells.
Have you prepared or not? Just trying to.
Learned from the
This is no way
argument, the argument advanced by the learned counsel for the petitioner. We find that he is not prepared in the case. Put up this matter after summer vacation. Yes.
You must know the provisions and all. You can't waste time like this.
Next.
Item 6.
After vacation, next.
Item 7.
Item 7 on behalf of Mr. Rashi Behra,
After vacation, next. All right, after
Item
vacation.
8.
Next item, to move after vacation.
8.
May please this one. Petitioner challenge the award passed by the arbitrator. The litigation proceeding. Challenge the award on the ground that on the same notification of nearby.
Which
villages,
order you are challenging?
I am challenging the award passed by the arbitrator under Annexure 6, page 44.
So you will come to the High Court. There is no other provision for challenging the award of the arbitrator. It is a,
This is the land acquisition proceeding.
yes,
On the land acquisition proceeding, the arbitration.
which provision would be applicable? Arbitration Conciliation Act re arbitrator order taku appeal file habo boli provision nahi.
34 is applicable.
Why have you come here?
Despite that, this honorable court can entertain.
Sorry,
There is
it
violation
appears
of-
that the petitioner has approached this court challenging the
in
order
support-
dated so and so passed in arbitration case number from
in support.
since alternative remedy is available to the petitioner in view under arbitration and conciliation act so and so the petitioner is at liberty to seek up alternative remedy in accordance with, so accordingly the petition is disposed of. Yes, next.
That's why I want to draft this.
Yes, next.
Item 10.
Despite the alternative remedy,
No,
this
people
court
go
can
there.
entertain.
No, yes,
8, 9, theta.
Why there is alternative remedy?
go there.
It's
Yes,
a
next.
9 also same man.
9, 10. Yes, next.
Item 10.
My pleadings. The petitioner limited grievance the dispute arose with regard to entitlement of compensation in land acquisition matter. The petitioner filed an application before the collector, and that is at Annexure 4, page 18 million, for reference of the matter to the authority. As per section 64 of the 2013 Act, the collector should have referred the matter to the authority. That having not been done, the petitioner is for final.
This is not a petition. Where is your prayer that it should be referred to?
But
This petition is not, it is just a representation.
yes, with regard to the entitlement of the petition, the petitioner.
Council, the application should be in a proper format and a prayer should be made that it is to be referred to the authority. In section 64, what it says? What is the power of the collector? The limited power is to refer the
For
matter.
the matter.
So where is that prayer in the representation? You have asked the collector that mate ଗୃହର ସମସ୍ତ ଟଙ୍କା ମତେ ପ୍ରଦାନ କରାଯାଉ
Yes.
ଆଉ ଘର ଖର୍ଚ୍ଚ ପାଇଁ ସମସ୍ତ ଟଙ୍କା ସେମାନଙ୍କ ପୁତ୍ର ମାନଙ୍କୁ ଦିଆ ନ ଯିବାର ଆଦେଶ ପ୍ରଦାନ କରାଯାଉ. No
This
such
is
prayer.
the prayer of the petitioner, my lord.
File appropriate application. This writ petition has been filed by the petitioner Murshid Ali Khan with a prayer for such and such. The Land and Council for the petitioner submitted that the petitioner has submitted an application before the collector Jashpur, that is opposite party number 2, which is purported to be one under section 64 of so and so act. And therefore the collector should have referred the matter to the authority. However, on going through the application, we find that there is no such prayer in that application. It is open to the petitioner to file appropriate application before the opposite party number 2 in accordance with law, on receipt of which necessary orders shall be passed by the opposite party number 2. Disposed of. Yes.
I made it pardon, worship. Item 8 and 9. So for limitation participation, I have to approach the decision.
File your defense. Yes, and take the
Item-
ground and section 14.
Section 14.
14 is there of the limitation.
Pardon. That observation also.
No, observation is not.
14 is always there statutory provision.
Yes,
Why
next.
should
Item
observe?
11.
Item 11, my lord.
Lordship taking fast over on behalf of.
Lord, I am taking 1 week time to file objection to the application for condonation of delay. 1 week time may be granted.
Delay is there.
Yes, my lord. Delay of 186 days.
Why is that office note? So that there is delay. In writ petition, what is the delay?
Not retribution, my lord. It is a criminal appeal.
Criminal appeal.
Afternoon.
That's the,
Afternoon comment oppose.
yes.
Lordship, item 11 taking fast over on behalf of Mishra.
land acquired by the national highway authorities and you want compensation
Yes, sir.
and
Have you approached the authority?
the authority have you approached?
Lordship, actually, the leading counsel, Mr. Bhawla, is in another court, that's why I'm here to seek Pato.
Yes, Parso. Next.
Okay.
Item 12.
May I please? The land of the petitioner was acquired by the special land acquisition officer for construction of the low-income irrigation project. Lordship, you can see the annexure 1. The land was recorded in the name of one Bhagdaram Jal.
Come to your prayer portion.
Lord, prayer to release the 50% of the enhanced awarded amount in favor of the petitioners. The land was recorded under annexure 1 in name of one Bhagdaram Jal.
No, where is that order passed by the court?
Annexure 5, running page.
Annexure 5 is your representation.
No, my lord. Annexure 4 is the sanction the decretal dues under section 18 1 amounting of rupees such and such.
Where is that order?
That order was not with me, my lord.
Find out that order. Compliance with the letter dictated, order dated so and so. Your claim is based on this particular order.
My lord.
27 to 2024 of the court of so and so.
My lord.
In LA reference case number 18 of 2021.
My lord.
So you are basing your claim on a particular judicial order and you will not file that order, certified copy. The claim of the petitioner seems to be based on the order dated 27 to 2024 of the Court of London Civil Justice Senior Division Nuapada in LA reference case number 18 of 2021. Stop. The said order has not been filed in this writ petition. Learned counsel for the petitioner seeks some time to produce the certified copy of the aforesaid order put of this matter after summer vacation. Yes.
Item 13.
May I please, your lord?
Yeah.
Item 13 state was to take instruction.
What instruction?
Instruction regarding the acquisition of land.
The paragraph number 5, he has mentioned what are the khata number, plot number, kishon, area of the lands of the petitioner and other co-sharers which have been utilized for construction of check dam in Kadam
Kadambanalia,
situated in Talavasta, Muja, under Dampada Tahsil of Cuttack district by the state. And he has not received any compensation. So whether this, we want to know, Mr. State Council, whether this land, the lands which have been mentioned in paragraph number 5 have been really utilized and no compensation has been paid. That is how you are asked to obtain instruction.
Instruction was sought for it has not come.
You have not received. No. All right. The Land Council for the state took some further time to obtain instruction as per the order dated 25/4/2025, put of this matter after summer vacation.
Item 14.
Item 14 by the lordship.
Yeah.
Lordship, this is a conform matter. In earlier occasion, lordship, passed by this honorable court.
Wait, the notice dated so and so.
Only, lordship, my humble lordship, liberty may granted to approach before the competent authority.
Person.
Because in the meantime, I already has been impressed. That's why.
Run and please. True.
Lost.
ଆଜିରେ ଆପଣଙ୍କର ପ୍ଲଟ ନମ୍ବର କରେକ୍ସନ ହବ ଯୋଉଟା କରେକ୍ସନ ହବ ଗୋଲ ବୁଲେଇ ଦେଇକିନି
ଆଜ୍ଞା
କରେକ୍ସନ କରି ଦିଅନ୍ତୁ ତାପରେ
Pencil ରେ କରିକି
ପେନସିଲ ଦେଇଦଉନ
okay.
Item 15.
Lords, I'm appearing in virtual mode, Lord. Lord, learned advocate, Attorney General was leading me in this matter. He's just stuck in some other court. Can you just have some sort accommodation for some time, not just a passover?
Yes, Passover.
Passover.
Grateful.
Item 16.
Seeking for a direction to clear up the diversion proposal pending before the appointment number 1 and 2 miles. After acquisition of the land for the purpose of Bengali Dam project, for the Bengal project, the father of the present petitioner has allotted some land extending acre of 4.90 decimal.
Come to your prayer portion.
Direction given to the opposite party, specifically opposite party number 1 and 2, to clear up the diversion proposal by the annex of 5 series.
What is that? Where it is mentioned that?
Annex of 5.
Series
Series page 33.
Which is the relevant page and paragraph. Annexure 5, which is the relevant page, and because it consists of page 33 to 44.
Yes, ma'am. So, give me some page 33, my lord. 33.
Yes.
I am to enclose here with a copy of diversion proposal initiated by Zone Officer cum Tahsildar Palada on the above subject. The user agency, that is Executive Engineer Bengali Dam Division, has submitted an undertaking for payment of all costs for the aforesaid diversion, which forms as part of the proposal, since it involves contempt cases in Honorable Orissa High Court.
So this is the letter dated 2011.
Yes, ma'am.
So what happened?
This is pending since 2011.
Why are you coming in 2025?
I can see this annexed 2, my how the delay has been made from the side of the state authority. Page 17.
What happened to these contempt petitions? Which are still pending.
And contempt, after receive the contempt notice, they have
No, the contempt petitions which are referred to in page 33. What happened to those contempt? Disposed of it pending.
After receipt of the contempt petition, the proposal has been made. After a long period, kindly see page 17 minor bottom para. These case records are moved from office to another office since 1983.
That is again the order of 2011. We are asking you that a pertinent question, that if this is the proposal is of the year 2011 and which was stated to have been passed after these contempt petition, etc. were filed, then why are you coming 14 years after?
After contempt notice, the state authority seeks 6 month time to comply the honorable court's order marriage. Thereafter, after conversion proposal given to the collector, they have submitted before the opposite part number 1 by.
When the last cause of action arose in your favor, you show us. Last cause of action.
Last cause of action
After 2011.
2011.
That's the question. If the last cause of action arose in 2011, why have you come in 2025?
By filing a representation in 2024.
2014.
You mean to say that the delay and laches on your part can be condoned when the cause of action arose in 2011 and you filed just a representation under Annexure 6 on 30/8/2024.
That may be considered Annexure 6. No. Kindly see page 17 how the delay.
Delay may be there, but what have you done for such a long time? You can't slip over your right and all of a sudden after a decade you give a representation and your cause of action starts from there. No, the cause of action is 2011. Merely because you have given a representation in 2004 doesn't mean that the cause of action arose in your favor. So explain.
Then let's say I am appearing for opposite party number 1. Take instruction.
What do you want?
So I will take instruction.
We have not asked you to take instruction. We are asking a pertinent question to the petitioner counsel. Why you are interfering and seeking to take instruction? Have we asked you to take instruction?
Sorry.
Yes. Have you explained anywhere in your writ petition that if the cause of action arose in 2011 and you just filed a representation in 2024 and then filed this writ petition 2025 in which view of the settled position of law, how you have explained the delay on your part for entertaining this writ petition after this almost 14 years.
Para 11, Mother, that
Para 11, what you have stated, let us see.
due to non-recording of land as allotted to their late father during the period of rehabilitation under Bengali multipurpose project, the petition suffered a lot from years together and could not able to avail the ROR, my lord, and any other benefits of the state and central government policy due to delay of conversion process, which is pending before the upper part number 2 since 2011.
Yeah, that is exactly 2011. Then the next line is that the petitioners finding no other alternative, no other remedy, approach this court before the opposite party number 2 by filing a representation in 24 and then coming to this court in 25. So you we graciously please to direct the respondent to quash the order number so and so under annexure 7. So you are praying for quashing.
Yes.
That was your prayer.
Now, which is rejected by
ଆମେ ଆପଣଙ୍କୁ ପଚାରିଲୁ ଯେ annexure 7 ହିଁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲେ ଆପଣ କହୁଛନ୍ତି ନାହିଁ
yes.
Sorry?
Annexure 7 को ସେଇ ଟାଇମ୍ ରେ
Annexure come to the annexure 7.
Yes.
That is at page number 62.
62.
Please place it.
It is intimated that Ministry of Finance has accorded in approval of grant of level 9 on non-functional basis to the post of supervisor on completion of 4 years of regular service in level 8 with effect from 1/1/2016 as in the case of assistant accountant / auditor officer in IA and AD department.
What was the petitioner?
Petitioner promoted as supervisor from 2014 and he got retired from 2017, 1/1/2017. He has completed 4 years of continuous service. And also another 12 member is there.
So this letter says that it came into force when 8th February 2021. So a decision was taken that with effect from 1/1/2016 ପରେ ଯେଉଁ ସୁପରଭାଇଜର ମାନେ 4 ବର୍ଷ ରେଗୁଲାର ସର୍ଭିସ କମ୍ପ୍ଲିଟ କରିବେ then they are entitled to get this benefit.
Yes.
So if you are not completed, when you completed 4 years of service, you retired in which year?
14 to 17.
In annexure 4.
14 to 17, you retired in the year 2017.
Yes.
The cutoff date is 1/1/2016. So therefore it is not applicable to you. That's what the court says.
Look, kindly see annexure 4 in running page number 56. Where another 12 officers are appointed as supervisor, which they have continuous service 2014 to 2018. And also three officers are there who was retired on
They were given
period.
parity you are.
Yes.
Parity you are seeking.
How the learning tribunal has dealt with this annexure?
Kindly the operating part of the judgment.
Now, have you argued this point before tribunal?
Yes.
What is the finding to that effect?
Yes, Mr. Page number 33.
Of the judgment of the tribunal?
Yes, running page number 33.
Yeah.
Where para number 17, in view of discussion made above, the decision relied on by learned counsel for the applicant have no application to the present case. Further, since the provision of NFU is clear and unambiguous to the extent that an employee on completion of 4 years of regular service in the regard of 4,800 will be entitled to consider pay by the screening committee on grant of next GP, which is 5,400. And admittedly, the applicant had ceased to be a government servant after his retirement 31/12/2017 and NFU become due to him on 1/1/2018. As per the decision of the Honorable Supreme Court in the case of Subramaniam Supra, this tribunal cannot interpret the provision and law in the different manner, only because of harsh of consequences arising therefrom to the applicant.
No. I have quite justified because you have not completed say you cut off date ରୁ ଆରମ୍ଭ ହେଇଛି 2014 ରୁ ତାହେଲେ ସେଟା 2018 ରେ ଆସିଥାନ୍ତା ସେତେବେଳକୁ ଆପଣ ଅଲରେଡି ରିଟାୟାର୍ଡ କରିସାରିଲେଣି।
ମୁଁ ରିଟାୟାର୍ଡ କରିଛି
31/12/2017 ରେ ଆପଣ ରିଟାୟାର୍ଡ କରିଥିଲେ।
31 କିନ୍ତୁ ମୋର as per the date of birth ମୁଁ 8/8/1958 ରେ ମୁଁ ଜନ୍ମ ହେଇଛି So more
No, we
retirement.
do not know. ଆପଣଙ୍କର ଯୋଉ ଡେଟ୍ ରୁ ଏ ରିଲିଫ ଟା ଆସିବ 4 ବର୍ଷ ଆପଣ ସେଇ ଡେଟ୍ ରୁ କମ୍ପ୍ଲିଟ କରିବା ଦରକାର ଏବଂ ଆପଣ ଯଦି ରିଟାୟାର କରିଥାନ୍ତେ 1/1/2018 ପରେ then you would have got that benefit.
One day before you retired.
Yes, but in case of notional increment, Supreme Court specifically held that in case of notional increment, the last day.
No, we put a pertinent question to you. You said that even some of the persons who have not completed 4 years,
Yes.
they were also given that benefit. You have shown that list now, and you have taken that ground before the tribunal also.
Yes.
And that is annexure 4.
Yes.
How the tribunal has dealt with it? Which paragraph? Because you may file 100 document, you may raise several grounds in your writ petition, but the grounds which you are placing before the court has to deal with it, not that whatever you have written in your petition.
They have only.
So we are posing you a question that suppose, let us say you have filed that document, but while arguing before the court, you did not take that ground. That means you are not insisting on that ground. So why the court will deal with it? That is how we are asking you that whether you raise that particular ground before the.
Come to your OA. In the OA, where have you taken that point? Parity point.
In page number 90.
OA starts at page number 35. Running page. আপনারা এখানে বাহার করলে ওইটা annexure 2 টা ওয়াকম ছাড়ুন ওয়াকম রে বাহার করুন পেজ নাম্বার 35 annexure 2.
The Lordship for instance, actually has not completed 4 years.
Now that we have seen. Yes. He says that some of the persons, as for annexure 4, who have not completed 4 years, they have also been given.
There is a case, he's completed 4 years just after 1 day of retirement. That is the case. So,
No. That least perhaps annexure 4 re, she page 44, yes.
That the applicant begged to submit that after retirement, he did not have any source of knowledge as regards the implementation of the circular under annexure 3, but was foundly expecting that he would get the benefit of NFU in pay level 9 with grade pay of 5,400 since he has completed 4 years of regular service in the cadre of supervisor as the date of birth was 1/1/1958 and he was deemed to have been in service on 1/1/2018, but the date of retirement on 31/12/2017 cannot stand as implement since all the purpose he has completed 4 years of service as on 31st December 2017. It is reiterated that the applicant has completed the eligibility criteria of rendering 4 years of regular service in the cadre of supervisor. The charges of which he assumed 1/1/2014 and continue as the till his retirement of superannuation on April 12, 2017.
That ground where you have taken, that is no ground. ଅନ୍ୟମାନେ ପାଇଛନ୍ତି ତାଙ୍କର କମ୍ ଥିଲେ ମଧ୍ୟ 4 ବର୍ଷରୁ କମ୍ ଥିଲେ ମଧ୍ୟ the benefit that you are claiming parity.
Come to page 49 in the grounds. 4 grounds you have taken nothing. Nowhere you have said that. Other people have got, I have not got.
Neither it was raised nor any ground was taken and you are claiming and you are raising that ground for the first time before this court.
This annexure was also not part of the, see, come to your index. Where have you filed this annexure? Let us see. Come to page 35. 36. Where is the annexure you have filed? In the index, so as have you filed the document? The said document which you have referring here.
No.
Then document you have not filed, not pleaded.
Mr. Counsel, this is totally, you see, unheard of. You are, please come to that annexure. Annexure 4. This annexure 4, this is a letter dated
26/3/2021.
Annexure 4 dated 26/3/2021. 2021. And your index, please come to your index, let us see.
Yes, it is fine for Bharat, I think the copy of order dated 5.
Serial number 5. The copy of the order numbers one for again, let us go to that. A by 4. It is
A by 4.
the A by 4 made a khali 4 achi.
A by 4. It is in list of date, the list of date 38. Including 3 retired supervisors. That's what he says.
This document has not been dealt in the judgment ordered by the London Tribunal.
Because se jagare mate jana hi nathila emti semane appoint hei.
Now come to page 44. Come to page 44. 4.6.
Yes, ma'am.
Read 4.6.
That the applicant humbly beg to submit that belatedly the office of the respondent number 2
implemented the circular under annexure A by 2, that is grant of so level pay. So 12 persons, including 3 retired supervisor of so. But you have not said that I am similarly situated, I have not been given. That you have not pleaded, but this is taken. This ground is taken mildly.
This has not been dealt, I think, in the impugned order.
You should have properly prepared all these things.
What is the counter affidavit on this particular paragraph 4.6? Whether counter affidavit has been filed or not?
No.
Oh, no, Kujan.
You have not filed. So as the counter if you have. How they have dealt with this paragraph? Parity paragraph?
Now I don't have that counter.
Sorry? What preparation portion?
A young man, you should prepare more than anyone else.
Counter affidavit is perhaps it is there in page number annexure 10.
40 minutes.
ठीक से पढ़ो ना दिखें ती ऑप्शन दी प्लीज करियो you are getting a platform London Council, don't forget that the proceeding is live streamed and your performance may attract others to give you case. This is the counter affidavit which you have filed and you are telling that I have not annexed the counter affidavit. Make the proper preparation. The London Council for the petitioner seeks for an adjournment, put up this matter after summer vacation. Yes.
You have to deal with this part.
Yes. Okay. On that reply page number 73.
Come after thorough preparation. Yes, next.
Page 23 deals with page 73, the relevant part. We are telling you. Yes.
Yes, next.
And
Let us support.
let's prepare.
Item 18.
Here the petitioners and of OP number 5 to 15 are the descendant of one common ancestor, Sheikh Maulana Abdul Ahad of Qatar town. They had vast extent of land at Atgod district. We will also kindly turn to page 14, Annex 1 with the record of right, who is this petitioner and the proper opposite party they have inherited.
No, who has determined your?
NHA has already determined. Now the compensation amount is lying.
Where is the document that they have determined?
You will also kindly turn to page Annex 2 at page 16.
Yeah.
They sought for a legal aid certificate from the Tahsildar way back in 2022. This acquisition took place in the year 2012.
It is the way so and so. It is once again requested to
For
furnish
payment of land acquisition.
list of legal heirs of late Maulavi so and so.
Yes. That is of the year 2022, February.
No, you did not furnish the legal heir certificate.
It is not, it is the Tahsildar to submit, not me.
Upon apply for
Yes, we had applied.
Oh,
We
you
had
had not
applied.
got-
To ascertain this authenticity.
Oh,
they sought-
authenticity, acha.
Yes. The Tahsildar was asked to submit the report.
What happened?
LR. Then you will also kindly turn to next page, page 17, October 2023. Again Tahsildar was intimated to furnish the legal heir certificate in a particular format indicated therein, and there was a mistake with regard to their address, residential address. That Maulaba Abdul Ahad, son of so-and-so of Mission Road, instead of sending the man of Bakrabad, you have sent this alias of, the person of Mission Road. That was the only mistake there. And it was pointed out by the Kala authority in the year 2020.
Ultimately, it was furnished or not furnished?
Yes, it was furnished. That is my grievance now.
Where is that?
It was furnished on the next page at Annex 4 in the month of
Annexure
March
4.
2025.
March 25 only.
Yes, that 12 million acquisition of the year 2012.
Wait.
One of my legal heirs is
Now it March it is done.
Milord, that is their duty to ascertain, Milord.
Alright.
I have been running, Milord. I have been running.
This now you see the legal heir certificate is before the authority.
Let them take a decision within the stipulated period.
Right. So this was on 28th March. And even 2 months are not completed. You have
That has happened only 3 years. This is the development, and I have been running from pillar to post. When I asked them, they said the matter is now the record is with learned decisions. Unless that record comes, we can't.
Problem therefore.
Yes, Milord.
There was some problem in the LR.
It is ground reality, Milord.
See,
That we can't get it.
ground reality is that sometimes also forced legal heir certificates are filed. That is why the authority is quite justified in seeking for that whether this legal heir certificate is genuine or not. So rightly they have done. Now the information has reached in March end.
Yes.
And we are in first. So
because
just wait for
medical
some time.
elements are there.
Only 1 month. In true sense, it
indicate that 1 month. Let them take a decision only. I don't.
No, it is only 1 month now.
Yes, sir.
It's
Let
March,
take a
April
decision.
only. We are in May.
2012 acquisition, Lord. Kindly appreciate. And the other,
All right, we're disposing
have already got.
that. Let us. The writ petition has been filed by the petitioner Ali Ahad with a prayer for a direction to the opposite party number 1, NHI represented through its chairman, to dispose of the compensation amount to disburse the compensation amount which has already been determined by him and to deposit the same
Already deposited in this. It is there in the country.
which has stated to have been deposited with opposite party number 2. Stop. The Land Council for the petitioner submitted that where have you stated that the matter got delayed on account of seeking this, you filed the legal heir certificate.
I have made an application to ascertain the value of authenticity.
The Land Council for the petitioner submitted that from Annexure 2, it would appear that a letter was issued to Tahsildar Sadar by opposite party number 2.
Yes, OP number 2.
Opposite party number 2 to furnish the list of legal heirs of late Maulavi Abdul Ahab for payment of land acquisition compensation, and several reminders were sent thereafter, and ultimately the
Next page at page 17.
and ultimately
Yeah, it was submitted, but there was some query by the Kala at Annex 17. Query is that you have submitted a,
finally kept phone.
sir, finally Annex 4
And finally, as per later dated 27/3/2025, the Tahsildar Sadar Katak opposite party number submitted the legal heir of the list of legal heirs of late Maulavi Abdul Ahad. The Land and Council for the petitioner submitted that at this stage, when the list of legal heirs has already been submitted, the authority should disburse the compensation amount, and therefore necessary direction may be issued to the opposite party number 1, 2, opposite party number 2 to do the needful. Though there was some delay as it appears from the records, but since the legal heir report of late So has already been received on 27/3/2025, it is expected that the opposite party number 2 shall expedite the matter in disbursing the compensation amount to the persons who are entitled for the same according to the writ petition. No question of this. Masses
Item 19.
May I suggest? See, petition को upgrade landowner of the land is land has been acquired by the OP number 2, but till now no compensation has been prepared. And earlier petitions approached Honorable Court and
to award compensation up to the petitioner in respect of so and so, including the compound interest.
So, petitioner earlier approached Honorable Court.
Where is that application? Where is that order which was passed earlier? Where is the order which was passed earlier by this court?
Page 84.
Page 84. Come to that.
That the land acquisition officer has submitted that no portion of the petitioner's land has been acquired. Therefore, the writ petition is dropped. For Lordship, thereafter, page 125, Lordship, as per the RI report, Assistant Engineer Candidature R&B Division, ସହଯୋଗ ଉପସ୍ଥିତିରେ ମାପ କରିବା ଜଣା ପଡେ
ଏଇଟା 17/4/2018 ଯୋଉ ଅର୍ଡର ପାସ୍ ହେଇଥିଲା ରିଟ୍ ପିଟିସନ ରେ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ଫାଇଲ ହେଲା ଏବଂ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ରେ ଷ୍ଟେଟ put forth kale that the land of the petitioner has not been acquired or utilized by the state. So the question of compensation, payment of compensation does not arise. And basing on that counter affidavit, the writ petition was dismissed. Right? Liberty was granted to you if you to utilize the land in question in any manner you like. So after this order was passed, what further remains that you are claiming again the compensation amount?
Page 125.
125.
Honestly, I think the RI report.
Just 125. Where?
Yes.
এটা হচ্ছে 16/1/2020 ର କଣ ହେଲା ଆଜି ଲେଖା ହେଇଛି?
Assistant Engineer Candidature R&B Division ସହଯୋଗ ଉପସ୍ଥିତିରେ ମାପ କରିବା ଜଣା ପଡେ ପ୍ଲଟ ନମ୍ବର 1426 ପେଜ 420
ହାଇକୋର୍ଟ ଯୋଉ ଏ କୋର୍ଟ ର ଅର୍ଡର କେବେ ଥିଲା, ଡେଟ୍ କେବେ ଥିଲା?
17/4/2018
17/4/2018 କାଉଣ୍ଟର ଆଫିଡେଭିଟ ଫାଇଲ କିଏ କରିଥିଲା ସେତେବେଳେ ଯୋଉଟାକୁ ମେନସନ କୋର୍ଟ ହେଇଛି?
Purchase the land, but that has not been paid in names. There, after rejection of reasonable court order, thereafter yet to file a civil suit.
Mhm.
The Lorna civil suit has a declared here purchase that land and that is that the government and decree has come out, there is page 160.
160.
Full additional land has been purchased and
160 बेल तो किसी पेज नहीं?
116.
Oh, 116 अच्छा.
116.
And thereafter, the inquiry is conducted and as per the method of annexure 17, that under process also, 134, page 134.
Oh, ये जो रिट पिटिशन ने डिसमिस होला परे आज इट अपियर सिविल सूट फाइल करछन. बनीता साहू, विनीता साहू, राइट. सिविल सूट रे ऑर्डर कोन हला? एक्सपर्टी डिक्री जी. जनापुर की पेज नंबर 116 ले ex-party order is right title interest of this one so over the suit land has been declared. अच्छा ए पर्टिकुलर लैंड टर्म acquired ହେଇଛି ବୋଲି ଏବେ ରିପୋର୍ଟ ଆସିଲା ତହସିଲଦାର जो जोटा कि से प्लेस କରୁଛନ୍ତି.
Thereafter, annexure 16 on page 130. This is
113.
One double three.
133.
Sorry. So that matter
No, thing is that suppose Vartaman Sina Akonare record hela by virtue of the order of the civil court, ta purpuru jahanare thibo compensation with the C payment he
that may be
my father's name.
No, if it was in your father's name, have you stated anywhere that your father has not received the compensation amount? Because the earlier petition which was filed, it was by you. Vinita Sahu is the petitioner in the earlier writ.
Again also.
And there you made the prayer that my land has been acquired. So, but it was stated at that point of time that there is no acquisition. But now the subsequent report has come that your land has been acquired, and obviously by order of this court. So
for that period, page 134 and 17
It's going on, the process is going on.
That on verification of the LA case record, it is found that this plot is neither mentioned in the land schedule nor in the within the acquisition area of the project. Need to status report of the following plot before 21/20.
but what about the Tahsildar's report? ये जोड़ा पढ़िले सी वर्तमान कितने पेज सेटा तहसीलदार को the place for
125
annexure 125. ଆପଣଙ୍କର आदेश अनुसार तदंत करिबारे स्वांश कहले तापरे आपण प्लॉट नंबर केते?
It's 1426 by 2512.
अच्छा 1426 एटा स्वांश को पत्यान प्रदान हेतु उपरोक्त दुई गोटी मूल प्लॉट 1426
131, 130, 130.
130.
After this representation disposal, there are orders, just see, 132. Process is on. Process is on.
Yes, therefore, submitted trace map of the fraction plot 1426 by 120, 1426 by 2509, and 1426 by 2774, and 4079. This is the of mother plot number was 1422.
whatever, why don't you ascertain what exactly has happened? So slow process. After 1 year, one letter. After 1 year, another letter. What is this?
This writ petition has been filed by the petitioner Vinita Sahu for a direction to the opposite party number 2, Land Acquisition Officer cum Collector Kendrapada, to award compensation to the petitioner for acquisition of land of area Ekorsun Swansum Dekhi. It appears that the petitioner earlier approached this court in WPC number 14358 of 2016 for payment of compensation for acquisition of his land bearing plot number Rauchi se order Tachi page 84 Swanso in the district of Swanso. In the said writ petition, counter affidavit was filed by the state wherein it is stated that the land of the petitioner has not been acquired or utilized by the state, and therefore the question of payment of compensation does not arise. Basing on such counter affidavit, this court had order dated 17/4/2018 held that the prayer of compensation cannot be granted to the petitioner. However, the petitioner was given liberty to approach the competent civil court for appropriate relief. Stop. It is the submission of the Land and Council for the petitioner that thereafter the petitioner approached the Land and Senior Civil Judge Kendrapada in civil suit number 256 of 2018, in which judgment was pronounced on 15/5/2019, and the suit was decreed ex parte against the defendants, and it was held that the right title interest of the plaintiff petitioner and pro forma defendants over the suit land measuring an area Ekorsun 12 decimal is declared, and their position over the same was confirmed. The Land and Council for the petitioner submitted that on the basis of letter number 2506 dated 3/4/2017 of the Tahsildar Kendrapada and Executive Engineer Kendrapada R&B Subdivision letter number 1-1 dated 28/11/2013, page number 125, Annexure 13, the RI has submitted a report wherein it would be evident that the aforesaid plot number 1426/420 has been acquired by the government stock. The Land Council submitted that in view of such favorable report of the RI, and since the land of the petitioner has been acquired for at a co-purpose में acquired इतना food लिखाई जी
Page 1,
133. अच्छा for extension of Jagatpur Chandabali Road, है ना? The petitioner is entitled to get the compensation amount which is has not been paid to her. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite parties number 1 to 5. Extra copies of the writ petition be served on the Land Council for the state. So far as private opposite party, but pro forma opposite party number 6 and 7 are concerned, requisites for issuance of notice, those opposite parties be filed within a week. Put up this matter after 4 weeks to counter affidavit, if any, be filed in the meantime.
What number that is 1465420.
जहाँ लिखा है हमें लिख दो से अमीनर यो आरआई रो रिपोर्ट रे
4209 is hard like that.
आरआई रिपोर्ट का कितना नंबर पेज रे देखो
125 page
125 अब लिखा है जी
146542009
4209 अच्छा ऐसे जो 420 को इधर ही सिर्फ 4209 पर जाए है ना बाकी सब हो जाए सेटा होची पेज नंबर कोई थी ना 125 रची annexure 13 है ना. So this is item number 19 na. All right, we are just coming within 2 minutes.
I think 15. It's come, but Are we audible?
Yes, yes,
Yes,
yes.
yes.
Please, sir.
No, item 15, I think it was passed.
Yes.
So
Please
uh,
place.
if that can be taken up subject to your lordship's convenience.
Please
Yes,
place
yes.
the matter.
Yes, yes. It's a very short issue, but having huge problems for Mahanadi coalfields. The issue is from land was thought to be acquired way back in 2013, and then till 2017, we could not get possession even though award was passed and compensation was given. So Mahanadi coalfields has to go for another alternate piece of land for our purposes. So from 2017 onwards, we are requesting the government to denotify this land under Section 48. Now, because of the spending, we are now flooded with a lot of requests for employment opportunities for land which has not been given to us, rehabilitation in respect of land which has not been given to us. And we recently had an issue before the High Court and matter came to Supreme Court. Then I found out about 37 such matters are pending with the collector regarding rehabilitation, employment, compensation, etc. As far as we are concerned, compensation paid in full. If the government says you pay a little more compensation, we can also do that. But the government must denotify this land so that we are not burdened with any liabilities attached to the land. So if Lord may issue an urgent notice and government can take notice and come back and report to the court next week, because some matters are coming for Supreme Court in next weekend. If that's why there is some urgency in this matter.
Okay.
But how can there be a mandamus for denotification under 48? Because if the land is acquired for our purposes, we don't require it. Government knows we don't require it. So how can a land which is not required by us? 48. From 2017 onwards, our request is pending with the government. The government can come and say, no, we will, whether you want it or not, we'll ask you to have the land. Then that will be an interesting case for argument.
The last communication that was made is Annexure 9.
Yes,
as
yes.
It to the collector.
Yes. That was because from 2017 onwards, we've been making large number of communications. All of them have not been put on record. Page 57, Lords will kindly see. MCL has consistently communicated that since the subject land was required urgently, and since the possession of the land was not handed over on an urgent basis, despite deposit of the entire compensation by MCL, therefore an alternative land was used, and such subject land therefore was not required as the urgent acquisition was not fulfilled. Thus, MCL has communicated repeatedly that the subject land be re-notified.
For denotification under Section 48, we can't issue mandamus. We can
what I'm requesting for your lordship is
To
may put it like this to clear your lordship's doubt. I'm not today saying that what the collector should or should not do. I'll address that question later. But let notice go to the collector, let them say what they propose to do in this matter. They can't keep the status. We'll seek the status. That's right. They should come and report what we propose to do.
For learning Attorney General, appearing for the petition, Mahanadi Coalfields Limited. This writ petition has been filed by Mahanadi Coalfields with a prayer for a direction to the opposite party, number 2, Collector and District Magistrate Hon'Ble, to consider the application of the petitioner and an annexure 6 and 9 for denotification in accordance with the Section 48 of the Land Acquisition Act 1894, and thereby denotifying acre 93.57 decimal of the acquired land at village Bad Jorda placing annexure 9, which is a letter dated 14/4/2023 issued by the General Manager, Jagannath Area MCL, addressed to the opposite party number 2. It was stated that MCL was consistently communicating that since the land was required urgently and the possession of the land was not handed over on an urgent basis despite deposit of the entire compensation by the MCL, therefore an alternate land was used and the aforesaid land was not required therefore it may be denotified, but no action has been taken by the district administration. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of you will accept the notice on behalf of opposite parties number 1 and 2. All of them. All of them.
We also then.
All of the parties. Extra copies of the writ petition be served on the Land Council for the matter be listed. Can you tell a date?
Any early date which may be convenient.
After ensuing summer vacation, our court reopens on 17th. So please give us a date so that which will be convenient to you.
17th of June.
Yeah. 17th of June, the court will reopen after summer vacation.
You are opening in July.
I know. I just look calendar philosophy. Just give me half a second. So it can be in the last week of June, first week of July. Take first week of July. It can be in first or second, any date convenient to lordship.
July 1st. Can it be in the first July?
First of July?
Yes, any
fine with me.
or 1st July 2025. Instruction be obtained in the meantime, and Mr. Satyendra Prasad, Senior Advocate, the appearance memo is filed, taken on record. All right. Okay, thank you.
Grateful to Lord. Grateful.
Item 20.
So, this is a single bench matter or service matter. By mistake, it has been filed.
It is
no
stated by the Land Council for the petitioner that it is a single bench matter. The registry shall verify the same and place the matter before the assigned bench. Yes.
Item 21.
Item 21.
Before placing this matter, madam, the 3 copy of this order I received today, so submitted with 3 copy of this memo.
What?
Improved order under annexure is
You are filing the certified copy.
that way.
It's a true copy, right?
This is a 3 copy.
All right. The Land Council for the petitioner has filed a free copy of the impugned order with a memo which is taken on record. Yes, what is your prayer in this petition?
Prayer of the petitioner is that we challenge the order passed by this
very particular order you are challenging.
My Central Administrative Tribunal passed in MA number 146 of 2025, arising out of OA number 108 of 2000.
What was your prayer before the Central Administrative Tribunal?
In the annexure 1, page 13, it is also quoted, my lord. In that same page 13.
Okay, page 13.
To quash the rejection of candidature of the applicant in final scrutiny list dated for 25/2/2025 under annexure A by 6.
to direct the respondents, more particularly respondent 4, to consider the candidature of the applicant for the post of deputy superintendent in archaeological chemist, taking into consideration or
So
qualification.
let us come to that annexure A by 6. Let us see that.
A by 6 is
Page number?
Page number 46.
46. 46 of our color. What is the ground they have
There
taken?
is no ground they have it has been mentioned. Page 48, my lord.
40?
My roll number it has only been mentioned. Page 48. Roman B, rejection category and roll numbers. Lacking of essential educational qualification only.
Just a minute. Podi.
My lord, page 48.
48 no?
48 B, capital B.
48 capital B.
Scrutiny, rejection category and roll numbers. Lacking essential educational qualification, that is last roll number 854, my roll number. My lord, before finally in scrutiny list, they have given a provisional list under annexure A by 4.
No, let us say that what was the educational qualification required?
My lord.
And what was your educational qualification?
You are MSc chemistry. You are MSc chemistry.
I am MSc in analytical chemistry. But the advertisement was MSc in chemistry, annexure A by 2, page 29, the advertisement.
Page 29.
The main way.
Where is the qualification?
Page 29. That is essential qualification is a bachelor degree in chemistry or master degree in chemistry. I have both bachelor degree.
If you have bachelor in the chemistry bachelor degree, you have organic chemistry, inorganic chemistry, analytical chemistry, everything. But in master's degree, you have got only analytical chemistry.
Analytical chemistry. My question is that, my lord, the same organization UPSC has issued an advertisement in the year 2017, that is, I have also enclosed in annexure A by 9, page 58.
Your candidature is rejected because you are only analytical chemistry.
That they have not essential, only that they have not mentioned anything in the essential, only they have stated that essential educational qualification, lack of essential educational qualification. I filed, and this Law and Tribunal has passed order subject to result of the original application. While the matter was pending.
What is the counter affidavit filed?
Counter objection to MA. Just one. Objection to MA. I filed an MA miscellaneous application, that is at page 60. That page 63, they have issued an interview schedule. Interview schedule where they have mentioned that page 63. Annexed to my MA. Interview schedule where in last line, offline application received as per directives of the Honorable CAT Ahmedabad, had its order dated 11/6/2024, subject to the final outcome of the OA number 182 of 2024. One in the Ahmedabad bench has passed order subject to result of the end, and he has been allowed to participate in the interview.
What he says that my qualification is there, my OA is pending. Why can't you allow?
Fine. The annexure 1 is the interim order. Why not make peruse that out? Page number 15 of annexure 1, my lord. Paragraph 7. Earlier, while the OA was taken up for admission, my lord, there was an interim order that any appointment pursuant to the said advertisement is subject to the result of the.
Why unnecessary? Why can't he appear? Why will he lose a chance?
My lord, his eligibility is under question, my lord.
He is MSc chemistry analytical. Your qualification is degree in chemistry.
Order of the Ahmedabad bench that they are putting, in that case, the issue is of age relaxation. Here it's a case of eligibility.
Let him participate. What is the problem?
No, question is that suppose in that eligibility criteria, where is that page number?
Page 29.
29. come to that page. The 29 page is your advertisement.
Right.
And there the essential qualification you have just mentioned that either bachelor degree in chemistry or master's degree in chemistry.
Right.
What type of chemistry, that is not specified. So he is having the master degree in what is it?
Analytical.
Analytical.
Chemistry. Page 26.
Page 26.
But in degree, you can't have specialized. Degree, you have to have entire chemistry,
Right.
organic, inorganic, analytical, everything. Though forget about a master's degree. He has a degree. Thereafter, he has done the master's.
Right.
Then how can you will not allow him to participate?
And, though that has not been specified, however, the CAT tribunal has granted the opportunity to file the counter affidavit in that order.
No, that is the information. Question is that 8 means tomorrow is the date fixed. He has come up with an
8 and 9.
uh,
8 and 9. Page 63.
He should participate and the outcome will be decided ultimately. For his career.
Also in the improvement of the CAT has observed that in case the application is found to be found successfully.
that is, suppose you delayed the matter and ultimately, let us say he participates and his case is rejected. We are extremely going to, let us say, rejected. So there is no question of, again, even if, so he will not never pursue that application. And suppose in the interview, he comes out successful and it is case, ultimately he wins the case. So there would be no problem in that way. If you file the counter affidavit on earliest, question is that why you will miss this one. Basically, जो जिनसे गुड़ा का दरकार, he has come up with that you are requiring this qualification. I have got that qualification. So once he is having the degree, so that is the only ground for which you are disqualifying him.
He's not asking for a job. He's want to participate. How can you prevent? But preliminary, he has his qualification.
Let us look on. This writ petition has been filed by the petitioner, Miss Pragya Parimita Jena, to set aside the order dated 2/5/2025 passed by the London Central Administrative Tribunal Patak Bench in MA number 146 of 2025. In dismissing the MA, holding that holding as follows, quote paragraph number 7. The London Counsel for the petitioner submitted that the original application has been filed with a prayer inter alia, with a prayer to quash the rejection of the candidature of the petitioner in the final scrutiny list dated 25/2/2025 on the ground, Aneshwar by 6 कितने पेज रहे हैं?
46.
46. 40.
But Lordship also see the page 66 para 2.
46 तो 46 टा उसी तो essential qualification reject जो हुई थी on the ground of lacking of essential educational qualification, the London Council submits that the essential qualification which was required was
BSc in chemistry or MSc in chemistry?
code page 29.
Lordship, page 66 we filed objection there we have mentioned.
Is that bachelor's degree in chemistry or master's degree in chemistry. And
1 year experience.
Petitioner, आपनकर येटा कहीं जो क्वालिफिकेशन है
26 sir.
26
sir.
26 टा बार का and the petitioner
25 certificate.
Petitioner has the degree of MSc Analytical Chemistry from Osmania University, and the certificates have been annexed to the original application, and therefore the rejection of the rejection page को पढ़े सुन page
48.
The rejection of the candidature of the petitioner on the ground of lacking of essential educational qualification is not sustainable in the eye of law. He submits that the petitioner may be permitted. Where is those two dates? We said that
page 63, sir.
63%. Since the interview fixed to 8/5/2025 and 9/5/2025, which should be evident from annexure A/10, pending disposal of the original application, in which order has been passed that would be subject to the result. Which is that order?
That is page 59, annexure
69,
59, sir.
59,
sir.
In which order has been passed that as an interim relief, the appointment made to the post in question shall be subject to the outcome of the OA, the petitioner may be permitted to face the interview in any of these 2 days. After hearing the Learned Counsel, Deputy Solicitor General for the Union of India, we allow the petitioner to, we direct that the opposite parties, who is to allow you opposite party?
Courts actually conduct the examination.
Union Public UPSC.
UPSC means this opposite party number 3.
3 and 4.
Opposite party number 3, and while setting aside the impugned order dated so and so, passed in MA number so and so, we direct the opposite party number 3.
The 4 are yes. 3 and 4.
3 and 4 opposite party number 3 and 4 to allow the petitioner to participate in the interview either on 8/7 so and so or on 9/7 so and so. The intimation shall be given Ajiala 7th itself to the petitioner, indicating the date of interview which she is to face, and a free copy of the order be handed over to the Learned Counsel for the Union of India to do the input. Allowed.
And only one point I am just enlightening the knowledge of the court. There is an objection, let's say, page 64 onwards.
You,
In
that
that-
main application is pending.
OA is pending.
OA is pending, you raise, we are just.
Written that interview schedule on 7/4/2025. That I
No.
allowed to enlighten my one.
Huh?
There is a affidavit filed by the authority.
No. This interview is pointing out that.
I have seen that, page 63. But the UPSC filed a affidavit wherein he has written that interview schedule that which annexed by my friend annexer 5 page 64. Page 66 it was written 7/4. That's why I am telling.
It is 7 kb ହେଇଛି?
Page 66 Lakshmi Company.
66.
Annexer 5 page 64.
64 अच्छा हाँ कौन है कोड लिखिए
Lakshmi come to the page 66.
66 अच्छा को लाइन का
UPSC has filed a affidavit before the
Interview
tribunal.
schedule and so on so annex.
हाँ डेटेड का होची 7/4/25 रे सेटा इश्यू हेची ऑर्डरटा इश्यू हेची सेटा पर सेतिर अछि देखो
63 रे
पेज 63 तो
हां सर
हां पेज 63 को आसन मिस्टर पारी 7/4/25 रे सिग्नेचर हेची देखो पेज 63 रे किंतु इंटरव्यू अछि दीटा 8/5/25 रे एई मानकर इंटरव्यू होबो ଆଉ 9/5/2025 ରେ ଏଇ ରୋଲ ନମ୍ବର କର ହବ ଦ୍ୟାଟ୍ସ ଅଲ୍ ଏଟା ଟିକେ ଶୀଘ୍ର କରିକି ନା ଗୋଟେ କପି ଦେଇଦେବି
it is better my lord the court can either UPSC council may communicate it or may communicate for the court so it is helpful to him also.
We are handing over the copy to you, just you communicate, do the needful.
Yes. That I'll do.
Item 22.
Item 22, my lordship. I place some more time to comply. Last occasion, my lordship is also granted a time on 25/3/2025. I'm sending the letter. That is the last chance may be given for that.
All right, the Learning Council for the states some more time to obtain instruction as for the order dated 5/3/2025 regarding compliance of the order of this court dated 5/8/2024 in WPC number 15513 of 20. ऑर्डर पास है 5/8/2024 रे समय दिया हला अपन को 3 मास from the date of production of the copy of that order and we are in May 2025 and you are not. This contempt has already been committed and dispose of the representation. So you may allow, you may reject, so that communicate the order. That all we want.
File affidavit.
That's last granted my lord in the meantime.
This order may be made peremptory. We are keeping it before this vacation and not take up after vacation. We are keeping it to next week. You file the compliance report. Consider the representation. Why is this matter? Today is 7th, so we are keeping on 14th of May 2025. Compliance affidavit shall be filed. Yes, next.
Item 23.
Item 23, I am appearing in BC from Delhi on behalf of the petitioners.
Yes.
I have been just told by my instructing counsel, Mr. Patra, he is in court. The opposite party has filed an application for vacation of stay. I have not received a copy of that. If that come after, if that matter can be taken after the vacation.
I have received. Is it received the copy? He has stated that.
No, Mr. Patra has received. I have not got a copy of that. I am in the right.
You have not sent. Well, it has not been sent to you. He said that he has received. So you want to.
I'll just go through that so that if it can come after the vacation.
I am the opposite party, Lordship. This is the case, Lordship.
You have filed the application.
He wants to file the objection to that.
Lordship, this court passed the order. In view of the Honorable Apex Court, this case is infructuous, Lordship. Because it is a notional increment, taking into account that order pending before the Honorable Apex Court, that has been disposed of.
He is now 70.
It's all right. Why don't you, that's a different matter you are filing. But if this notice has been issued, so if you are
And
the
there is a
opposite
stay also,
party,
my lord. There is a
will
stay
you file the
because
counter affidavit so that matter. Where is that?
His lordship, I filed earlier.
There is not in that, in this writ petition.
29/1/2023, your lordship.
Have you received the counter affidavit?
Yes,
So where is the counter affidavit?
I beg.
Just a minute. We want to, because in the record we do not find it. So if the counter affidavit is already there, this is the counter affidavit. No.
Yeah, very
So to be very fair to the court, my lord, actually what my learned friend is saying on behalf of the opposite party, he's quite right, but I just want to go through that application because as far as my knowledge goes, the Supreme Court has already held that notional benefit can be extended, but still I just want to cross check.
The Supreme Court order
Because actually when the stay was granted, I was appearing and I referred to an SLP 4722 of 2021, where the Supreme Court has
As per the
stayed.
Supreme Court order, if it is infractuous, then it can be disposed of.
No, I right now I don't have the copy of the orders. That's why I'm saying it will come after the way. It's a matter of just 1 month's time, my lord.
1 month and implemented that order, your lordship. Implemented also this order, your lordship.
This has already been implemented.
Yes.
Some cases that have been implemented. Some cases.
Your lordship,
Notional increment. Here, disputed fact is that he is retired on after date of notional increment.
36/2008, I have retired. Notional increment date is 1/7/2008.
And secondly, we have to see whether the order is applicable in general for all the department or it was for a specific department. Because I'm not aware whether any benefit has been given for this particular CAG office.
This department also implemented. Your department also implemented.
Okay. Counter affidavit केवे फाइल करने डेट कर देना? Yes, sir. लिखो ना नहीं. That is the counter affidavit file is here. This is the index to the prepare. WPC number says counter affidavit is there. You mention it in this. Page in it କରନ୍ତୁ. Counter affidavit file ହେଇଛି ତାର page number ଦିଆ ହେଇଛି.
Sir, your lordship.
Just a minute. The learned counsel appearing for the petitioner submits that he has received the interim application for vacation of stay, which has been filed by the learned counsel for the opposite party, and intends to go through the same and, if necessary, file objection to the interim application. It further appears that the opposite party has already filed the counter affidavit and it has been received by the learned counsel for the petitioner. You don't want to file any rejoinder. Let us be clear on that so that we'll fix the next date for final adjudication. Or
it would be better let the rejoinder option be open. We can just go through the counter and file it if required.
Okay. The learned counsel for the petition opposite party submitted that in view of the judgment dated 11th April 2023 passed by the Honorable Supreme Court in Civil Appeal number 2411 of 2023, which arises out of SLPC number 6185 of 2020. The claim of the petitioner cannot be entertained. The decision is taken on record. List this matter on, let us put it and give a date on, we fix that day, case to the case to 1 तारीख ना जोड़ा Attorney General appear करते so keep it. We are keeping it on 2nd July 2025 and resender affidavit, if any. So also the objection to the interim application be filed in the meantime. Interim order dated 14/10/2022 shall continue till the next date. Yes.
My appearance may be noted, my lord.
So we please give me.
Give in writing.
Give in writing so that we can sign.
These thoughts in out.
These are also final disposal. Password is still
Passover item number 11.
Mr. Manas Ranjan Dhar. What is the prayer here? Land acquired compensation not paid by the National Highways Authority. That annexure 4 indicates that the representation is to be submitted to the project director NHA, but or chief general manager so and so for further action. Before whom you have submitted the representation? Chief engineer for coordination. All right, let the non-appearance repeated call put of this matter in ensuing summer vacation. Mr. Das, which is your item?
Item 27.
We are all for final disposal.
Final disposal, yes. Yes, Mishra. The other side is now go.
Yes, sir.
The regional copy that I have already filed by the petition.
Just now.
He needs a copy of that.
I have already saw.
Yes, sir. Just now. Yes.
Morning she mentioned it.
Sure. The opposite party is not filing, MCL has not filed a counter, and it is already taken one in application.
37.
37. He is present, my lord.
37, Dilip Kumar Singh Dev.
My lord.
37 Davar.
Yeah.
Notice has been issued and to the parties. Nobody has filed any counter affidavit.
No.
Let us seek some time to file counter.
1 year past, last order may be kindly.
The order is dated 14/8/2020. You are appearing for whom?
7 and 8 MCL.
7 and 8.
Yes.
MCL. You are the main contesting party.
Yes,
Why are you not filing?
Lord, I seek some time. Hello, 1 year passed from the last order may kindly be seen.
And counter has been filed by opposite party number 3 and 5. You have received the copy of the counter. All right, you are not seeing that, you are not telling about that also. The counter filed by opposite party number 3 and 5, you have not received the copy.
Yes.
All right, item number 37, the Learned Counsel for the petitioner submits that though counter affidavit has been filed on behalf of opposite party number 3 and 5, but the copy of such counter affidavit has not been served on him. Who is appearing for opposite party number 3 and 5?
State Council.
Collector and Land Acquisition Officer. Let the Learned Counsel for the state supply the copy of the counter affidavit filed by the opposite party number 3 and 5 to the Learned Counsel for the petitioner. Stop. The Learned Counsel appearing for the opposite party number 7 and 8 seek some more time to file the counter affidavit. Stop. Learned Counsel for the petitioner objected to the same on the ground that notice was issued on 11/7/2024 and stop. Put up this matter in the week commencing from 7th of July 2025. Counter affidavit, if any, be filed by the opposite party number 7 and 8 in the meantime, serving copy on the Learned Counsel for the petitioner. After receipt of the counter affidavit, the rejoinder, if any, be filed by the Learned Counsel for the petitioner, serving copy on the other side.
Let's do this. Next item. I'll 24 may can do it.
24. What 24?
Item 24. No, 24 item, the board.
This will remain, it will come tomorrow. All these matters will remain. This matter you mentioned, that is why.
My bad.
Yeah.
Supplemental list, item number 1.
Yes, Your This is an appeal against acquittal. Like the respondent number 2 is acquitted from all the charges, that is at page 36.
State is not filing.
It is not filing. I will take it on that because
Victim has supported the prosecution.
Yes, sir.
Have you got the copy of the statement of the victim? What is the age of the victim?
11.
11 years.
Yes. He is 76. AB is there.
No, it's all right. Just we want to see that. What is the ground of acquittal?
My lord, the evidence is inconsistent, the court below says, and as the medical report not supports.
How many days after the occurrence he?
Immediately, my lord.
Then how the medical report negative?
He says one cannot commit sex regularly for 5 days. It is also a observation.
No, the rest of them now, but order of chief increase. Yes, item number 2.
Please, Your Lordship. The appellant has preferred this appeal against the order of conviction, Lordship, wherein the appellant has been sentenced to undergo life imprisonment for alleged commission of offence under section 302-34, read with section 364 and 34, Lordship.
Call for the trial court report.
Co-accused.
Yes, Lordship. Next item is the
item
Next.
No, please.
Item 3.
May I please your Lordship that we have been convicted under 302. 3 persons are there. Actually, the alleged incident occurred on the 2nd July at 6 p.m. But the FIR was lodged on 4th July at 2 p.m.
No, what is the sentence imposed? What is the conviction and what is the sentence imposed?
So we have been convicted of life imprisonment.
That's not it. Admit call for the trial court report. Interim applications for bail and sterilization of fine. After receipt of the trial court report, deposition copy to be supplied in the meantime. Yes, next.
Item 4.
The appellant is convicted under section 302 and other offences of IPC, Your Lordship, and the maximum sentence is the RI for life, Your Lordship.
Same order.
Item 5.
Appellant is convicted under section 202/34 IPC and sentenced to life imprisonment and fine.
Same order.
Item 6.
Appeal against conviction. And the appellant has been convicted under section 302 and sentenced to imprisonment for life.
Same order.
Item 7.
7 is also same.
7.
Then is appellant sentenced to undergo
Admit.
convicted under section 302.
Item 8.
Convicted for offense 302, life imprisonment.
Same order.
Item 9.
Assault. अच्छा तो ओके जस्ट कितने जन appellant ଅଛନ୍ତି କି? 2 ଜଣ. Date to produce report regarding conduct of the surrender certificate not yet filed. Trial court of अच्छा In the surrender the interim application of this surrender to court the okay. Non-appeals put up this matter after summer vacation, yes.
Item 11.
Ensuing summer vacation. Yes, next.
11 item, I am for the respondent. I pray for next week to file objection on.
What objection?
I have delay petition 186.
11 item, my lord, was the bail
Yeah,
application.
have patience. You want to file objection to what?
Delay,
Delay, condonation of
Where is the delay?
186 days.
No. Which criminal appeal there is delay? Acha, CRLA number 52 of 2023.
23.
Let us see the last item that they can. $186 days delay, it's a life imprisonment deal on अन्य गुड़ाक को अपेलेंट करो सब एडमिट ही गलानी और डिले कौन ऑब्जेक्शन कौन फाइल करिए लाइफ इंप्रिजनमेंट इशू ना अच्छी कौन डिले ग्राउंड रे तो डिसमिस कर दूं ना कौन था क्रिमिनल अपील है
52 ना
हाँ दिस इज लास्ट आइटम ये जो क्रिमिनल अपील 52
ग्राफाइट इंडिया कौन
हाँ
ग्राफाइट इंडिया मोटर किसी ग्राफाइट इंडिया कंपनी पड़ेगा
what the
sales division. What is the name of your client?
1 to 11.
Huh?
Hamras Arjujuda Bhajmasika Sambubag
no it's all right
One person convicted and others
right.
are accused. May I make a prayer, Lord?
how many persons face trial?
What is that? Graphite India.
Lord, may I make a prayer, Lord? Mr. Patnaik is appearing for the informant company.
Your company.
Lord, may I kindly give one person?
Just a minute. Accused persons namely so-and-so are acquitted of the charge. So, who is the informant in this case?
Lord, the security guard of the company.
So, company can't be a party.
No, the informant.
The informant,
No,
Graphite
informant
India.
is Graphite India is not the informant. Informant is
The security guard.
Online. HR administration, what is this?
Lord, may I kindly grant one password?
Let us see who is the informant.
Ashok Kumar Paul is the informant. Raul. Ashok Kumar Raul is the informant in this
has he been examined as PW? In the trial court, who is PW number? Informant कितने number सकी?
In that case, my lord,
Ashok Kumar-
appeared. But I am
Ashok Kumar Raul is PW 19. So, informant is Ashok Kumar Rao.
He is a member of the security staff in their company, informant. How company can be a party?
The right has been given to the informant or the victim to challenge the order of acquittal. So here the informant is Ashok Kumar Rao, who was of course the security guard. So has he left the service or what?
He has left, my lord.
Huh?
He has left.
Then this type of appeal can be filed by the family members of the deceased also. Somebody
Lord,
has
they can-
died now.
They could also file.
So why we are asking a question that why company has filed. either informant or any victim, they can file the appeal. So the family members of the deceased is not.
So they do not belong to Odisha.
हाँ
They do not belong to Odisha. So
ओडिशा हो कि जा हो लॉटा होची
my lord.
जे एई माने ही फाइल करि परिबे दिस प्रोविजन
Informant or victim of the family.
Lordship
This-
actually pass over Mr. Patnaik will appear.
372 CRPC ର provision
No, I am appearing to the respondent.
No, that's right, but you want to file reply to the condemnation of delay. But how we see the complaint, the petitioner, appellate here.
the 372 says that provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offense or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction. And victim has been defined in section 2.
A juristic person can't be a victim in a 303 case.
Victim has been defined in section 2WA.
A person.
Victim means a person who suffered any loss or injury by reason of the act or omission for which the accused has been charged, and the expression of the victim also.
My lord,
guardian or legal heir. So how the company will file?
My lord, Mr. Patnaik is on VC if you support.
Yes.
Yes.
He was.
All right, we are you satisfy us, right? Look on criminal appeal number 52 of 2023. This criminal appeal has been filed under section 372 CRPC by Messrs. Graphite India Limited, Phoenix Steels Division, represented through its Assistant General Manager, H&R Administration, Sri Sarosh Kumar Naik, as the appellant, challenging the judgment and order dated 12/5/2022, passed by the London Session Judge, Sambalpur, in ST case number 29 of 2020, in acquitting the respondents number 1 to 11 of all the charges. Stop. Section 372 CRPC reads as follows. Quote further. The definition of victim has been enumerated under section 2WA, which is as follows. Quote further. In this case, the informant is one Ashok Kumar Raut, who has been examined as PW19. Stop. The London Counsel for the informant shall apprise this court as to how, at the instance of the company, this criminal appeal is maintainable. Put up this matter after ensuing summer vacation.
Grateful, my lord.
My lord, can I pray one thing, my lord? On that day, my lord, state has filed appeal against acquittal also. So it may be taken up with that also.
This order also, this is.
State has filed. That is the main application, my lord.
This should be come with along with all. 8 53 रे मध्य এই ঘনশ্যাম মহানন্দা কিଏ?
Same, same, same.
ସେ ବି ଗୋଟେ ଆକ୍ୟୁଜ ଥିଲା ଯୋଉ 50 ଜଜମେଣ୍ଟ ଟା ଦେଖି ଘନଶ୍ୟାମ ମହାନନ୍ଦା ଆକ୍ୟୁଜ। ଘନଶ୍ୟାମ ମହାନନ୍ଦା is also one of the accused. And he has been found guilty or acquitted. Accordingly, accused person so and so were अच्छा ये आउट ट्रायल भी
Out at right.
अच्छा सेम माने
Same affair, but
Same. There are different trials, my lord. Split up
case
लिखी
number
trials.
same proposition of law is same, है ना? And this is to be listed along with the CRLS so and so, है ना? और
Much obliged.
हाँ
Much.
हाँ
My prayer is the 486 486 by 2018. He is in custody more than 14 years or 3 months.
IA number 1193 of 2018.
My lord, just my lord,
2018.
my lord,
Acquitted.
regarding that, my lord, I'm just reaching court, my lord, just reaching court.
Right. This is the custody certificate.
बरोबर. You were released on bail for a interim bail for a
Interim
period
bill
of-
से जाई नहीं कॉपी अच्छी गला नहीं 15 दिन बोली गला नहीं
अच्छा
एक गले कॉपी
One of the eyewitness.
ये पहुंचला को ही गला तार बाहर सरी गला नहीं से गला
ठीक है. So you are now moving the bail application on merit. Earlier it was not rejected on merit.
ना किसी में रिजेक्टेड है नहीं मेरिट रे
Just a minute. Have you got the deposition copies? So
Recording there.
now, on what basis this man has been found guilty, whereas the other co-accused persons have been acquitted? What is the reason assigned by the London Trial Court? What are the materials against you?
PW 11 is the eyewitness, my lord.
11.
11.
Trial Court judgment bar PW 11. What he has stated against this man, particular Kumar Bagh. What is the name of the deceased? Mr. Pradhan?
Radhesham Rai.
Radhesham Rai.
Radhesham Rai.
Radhesham Rai.
DGM of the company.
DGM
Of the company.
DGM of the company, my lord.
Achha. What the eyewitness has stated about this man who was found guilty, Kumara Bagha. Madam,
सेम पुट्टी के तो समझते अथन
please show us that why he has been, the man has been found
गाड़ी
guilty.
अटके थिला तारा उती एति की होची से गाड़ी
Please show us from the evidence of PW2 PW11 regarding the specific overtake, if any, attributed against your client.
और ओइलानी तो उधर पर पिन मत ना
Are you not following us what we are asking you?
Para 3, my lord.
Paragraph number 3.
The said Bolero jeep occupied by Radhesham Rai and Vichitrananda went out of the main gate and went up to 50 feet from the gate where I noticed and was about to touch the main gate. Kumara Bagh, the present agreement, accompanied with the Ranjan Naik came in front of the jeep and gave signal to stop the vehicle. Accordingly, the driver, Kamal Bera, stopped the jeep and went outside and closed the gate of the driver jeep. I ran to the spot after the vehicle was turned and ascertained the reason as to why the vehicle was turned. I stood by the side of the jeep where Sri Rai has occupied seat. I also found 30 workers staying in Dharana. Outside of the plant by holding a tent came from the backside of the tent armed with lathis, iron rods, stone,
broken bottles came to the spot. One Venkatesh Mishra out of the workers, first of all, pushed me. The other workers accompanied Venkatesh Mishra, charged me saying to leave the place immediately or else they were assaulting. Thereafter, all the workers started attacking the jeep by the stones, iron rods, and lathis, as a result of which the glass of the vehicle was broken. The workers forcibly opened the front door and told Vichitranda Panda, who was occupying the front seat of the jeep, to come outside of the jeep and to leave the place. Thereafter, Sri Panda came out of the jeep and went to the shed. Mohtab Kharsal and Venkatesh Mishra brought petrol from the nearby camp in a two bottles and sprayed the same through the vehicle. And also they poured the petrol over the body of Sri Rai.
Mohtab Kharsal and
Mohtab
Venkatesh
Kharsal
Mishra.
threw a light matchstick to the jeep, and Venkatesh Mishra threw one half burnt cigarette aiming towards the Rai. The vehicle
What is
suddenly
against this? What is against this man? Only stop the car.
Only
No. My lord, also my lord, I'll point out, my lord, that there is a direct allegation against this man. That is what, my lord, just can it be taken up tomorrow, my lord?
No.
Yes, Mr. State Counsel.
My lord. Mohtab
And who else?
Mohtab Kharsal threw a light matchstick to the jeep, and Venkatesh Mishra threw one half burnt cigarette aiming toward the Rai. The vehicle suddenly got fire. After the Rai was burning by fire, he also came out of the jeep and fell down on the ground. One Madan Jal out of the workers brought a stone and threw aiming towards the face of Sri Rai. After this incident, all the workers fled away on the spot.
Okay, this is one evidence of the eyewitness.
My lord.
Is there any eyewitness?
There is another, my lord.
Who is he?
Two witnesses are there. Just 5 minutes there.
PW 11.
All the rest have not supported the case because what is
These are the witnesses.
PW 14 I have been knowledge in the date of I have mentioned. To my knowledge, my agent police personnel from performing, I found that Bolero Haitala. The passes we used to run.
My lord,
Reached all I did not, so on the same day around evening I could search. Next PW 15, nothing. 16, nothing. 17, nothing. 18, on that day, the PM doctor, David 19, presence of the seizure witness, 20, seizure 21,
my lord, if my
22,
$27.
22, 30, I am not saying.
27.
27.
Complaint to informant.
27. I'm the informant. That's one.
27 or is the informant?
Read 27. The informant.
Informant.
I know the accused Gauri Shankar. I have seen their things also. There are labels also. When I joined the office, accused Kamal Bera was unemployed. Kamal was not an employee of this one, but he was working as a driver. Except the accused Kumar Bagh, all the accused persons were the member of Swanso. Kumar Bagh was a member of Swanso Show. of his Lordship was the General Secretary, all of the people placed under suspension, so on. I was performing my duty in the main gate. At that time of joining the accused persons belonging to Swanson, agitating in front of the gate of Formex, and from fourth, police were deployed in the main gate. They said, I have a duty in the main gate till Swanson. Occurrence took place on the duty in the main gate. At about 4:30 p.m., the members of this Swanson held meeting campus. In the state meeting, all the members concerned. Okay. My Lord, I handed over the 10 members of the Swanson regular inquiry. Maintain active front.
but not relative incident. The informant is not the witness to the incident. He is narrating what transpired.
No, there are two witnesses.
Dharna.
My lord, kindly appreciate one thing. Why
He is only maybe a witness for motive. That's
my lord, one thing. My lord, there was a conspiracy in Chandiman. That is one part of the story. What is relevant, why this person was found guilty, because my lord, one unlawful assembly, others were acquitted. But why this person was found guilty? The main reason, my lord, is at page 43. Why, my lord? He was found to having burn injuries, my lord. And he was part of that unlawful assembly. And he was found to be with burn injuries. Page 43 of the judgment, my lord, may see for a moment. Para 35. I will corroborate it, my lord, with deposition of
we are not finally hearing. We are just
Mr. Patnaik,
my lord,
a single person cannot be convicted for this unlawful assembly. 149, it requires at least 5 persons.
That is where, my lord, the state has filed appeal against
everybody has been accused.
Why this person was entangled, my lord, mainly, leaving aside that for an unlawful assembly, my lord, he was involved in setting the jeep at ablaze, my lord, and he has set the fire.
The PW 11 says otherwise.
No, my lord, kindly speak. PW 27 is also a relevant witness, my lord.
Yes,
kindly, my lord, just let me read out page 43 for a moment. Page 43 is PW 8. Assistant Surgeon ST Hospital, Titlagarh, has disposed that on 7/3/2011 at about 3 p.m. on police requisition, he examined Kumar Bag, accused, Polton Bag of village Sailini under Titlagarh PS, and found the following injuries. Burn injury of side.
He is having injuries.
Yes, my lord. He was having burn injuries.
Yes.
Now, my lord, coming straight. My lord, PW 27, page 8, para 5.
You want the custody certificate on?
My lord, the accused, Commodore, told me that
Who has told burn injury? What that was put to the accused and 313. So,
yes, my lord. Yes.
so 313. What is it? Was it put?
Setback for the calendar will asset. I'll satisfy my lord. Just look at the picture.
No, Dexter will have satisfied. Kumar alias Kumar Bar. कितने दिन हुई थी ना?
14 वर्ष 3
फूड जाएंगे?
फरवरी 21
4360 मान
7 दिन 2021 रे आरएफपी फरवरी ହେଇଛି
ଆପଣ ଲେଖା ହେଇଛି ପୁରା A plus B plus C ହଉଛି 4360 4360
ହେଇଥିଲା ସେମାନେ ଦେଲେଣି 2 ବର୍ଷ ପାଖାପାଖି ହବ କି ବର୍ଷେ ପାଖାପାଖି ହବ ଆପଣଙ୍କର
ଏଇଟା କେବେ
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଟା
ଏଟା ହଉଛି 9/3/2023 ର
ହଁ ଏବେ 25 ମସିହା ହେଲାଣି
ଆଚ୍ଛା ଆଉ 2 ବର୍ଷ ଗଲାଣି
My lord, page 36, my lord, I am answering to my lord's query. During his examination under section 313, on being questioned regarding such burn injuries, the accused Kumar Bagh has not given any explanation except stating that he had not sustained any such injury. When presence of accused Kumar Bagh is well vindicated from the unambiguous testimony of PW11 and the occurrence is overwhelmingly proved by the prosecution and sustenance of burn injury by the accused Kumar Bagh is established from the testimony of Dr. PW8, giving bald denial without any explanation is a strong circumstances among Kumar Bagh. Testimony of PW8 corroborates the direct evidence of PW11 regarding the involvement of accused Kumar Bagh in such occurrence. So also the seizure of such order of dismissal of Kumar Bagh
Lit the fire and all. Everything is prescribed.
Are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the informant. This is CRL number 486 of 2018. The learned counsel for the petitioner producing the custody certificate of the petitioner issued by Superintendent District Jail, Balangir, submitted that the petitioner is in judicial custody for 14 years. And there is no chance of early hearing of the appeal in the near future. He submits that the PW11 is the only witness who has implicated the petitioner directly in the commission of the crime relating to the murder of the deceased Radhasyam Rai. But from his evidence, it would be evident that the petitioner came in front of the jeep and gave signal to stop the vehicle in which the deceased was there. And thereafter, co-accused Mahatab Kharsel and Venkatesh Mishra brought petrol from the nearby camp in 2 bottles and sprayed the same on the vehicles and also poured the petrol over the body of the deceased. And then Mahatab Kharsel threw a lighted matchstick to the jeep and Venkatesh Mishra threw one half burnt cigarette aiming towards the deceased, and the vehicle suddenly got fire, and after the deceased burnt by fire, he came out of the jeep, fell down on the ground. The Land Council submits that all the co-accused persons who face trial with the petitioner have been acquitted, and therefore the conviction of the petitioner with the aid of section 149 of the Indian Penal Code under different offences are not sustainable in the eye of law. Learned Counsel for the states, also the Learned Counsel for the informant, oppose the prayer for bail and place the evidence of PW 27, the informant in the case, and also the evidence of the doctor who conducted postmortem examination. Kiye kartila postmortem examination?
PW8.
PW8, the doctor who conducted postmortem examination, and opined that there were burn injuries on different parts of the body of the deceased, and PW, he has not conducted the postmortem examination. He has examined.
He was examined, Kumar Bas. He has not examined. He has only
placed the evidence of PW8 who examined the petitioner and noticed some burn injuries, and also the doctor PW18 who conducted postmortem examination over the dead body of the deceased and opined that the cause of death was due to shock on account of extensive burn, about 95%. Considering the submission made by the Learned Counsel for the respective parties, nature of evidence adduced during trial, the nature of overtact attributed against the petitioner, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail subject to condition that he shall not indulge in any criminal activities and violation of any terms and conditions shall entail cancellation of bail. Yes, allow.
Can I pray one more condition, my lord?
Yes.
Okay, he should not be allowed to come near the factory, my lord. At least that much, because बहुत लोग अचानक
is solid. Is next. Item
12.
12, state to obtain instruction about the
Item number 12.
12, no bail application has been filed. So
He has
you have obtained the conduct.
May it be surrendered in time.
All right.
I tried my level best to get the surrender certificate because it's
The Learned Counsel for the appellant submits that he has received instruction that the appellant, after availing the interim bail period, has surrendered before the trial court. However, since the surrender certificate has not been filed, let the register judicial obtain instruction from the trial court by whether the petitioner has surrendered after availing the interim bail period or not. File be placed before the Learned Register Judicial for such purpose. The Learned Counsel for the state shall also obtain the report regarding the conduct of the appellant during the interim bail period put up after summer vacation. Yes.
Item 13.
In this case, the notice has already been sufficient. And it has suffered many adjournment due to non-appearance of the victim. And the petitioner, who is aged about 18 years at the time of incident, is inside custody since 4/5/2018.
What is the instruction? Right, here is the report submitted by the IAC Sasson Police Station, Sambalpur, wherein the informant has stated that the government advocate may contest the case on her behalf. The report is taken on the report. Yes, what is the case?
Well, the case of the prosecution is that the victim aged about 4 months. conviction is for life.
What is the conviction under what offences you have been?
For life, my lord. Your lordship may kindly come
No,
to
376 2I
2I
and 46 and 376 DA. You are, what is your name? Afzal Raja.
my lord.
Afzal has been found guilty under what offences?
376 I, my lord.
2I.
2I.
2I and section 4 and 6.
Read with section 4 and 6 of also.
Victim, who is victim?
PW? The victim could not be examined because she committed suicide.
Okay.
Well, prior to that, on merit, the person who were convicted under section 376 DA have been relaxed on bail by this honorable court.
been convicted under 302, 307, 120 of IPC, life conviction and 10,000 fine, my lord. This is for interim application, my lord. Earlier, my bail application was rejected and this honorable court directed to prepare the paper books, my lord. In the meantime, 2 years passed, my lord. My lord, what happened?
On what ground you are seeking for?
My lord, medical ground, my lord. The father of the petitioner is a paralysis patient and wife is also arthritis.
Have you obtained instruction on this?
No, my lord.
IA number so this is an application for interim bail on the ground that the father of the petitioner is suffering from paralysis and so his wife suffering from arthritis. Medical reports have been annexed to the interim application. Learned counsel for the state has received the copy of the interim. Submit that he has not received the copy of the interim application. Let the copy of the interim application be supplied to the learned counsel for the state in course of the day with the medical documents in order to enable him to obtain instruction put up after summer vacation.
Item 15.
My lord, the jail criminal appeal and I have been engaged by through the legal.
What is the conviction is under section 302.
302, my lord.
So it's a case of direct evidence or circumstantial evidence?
My lord, case is of direct.
1 and 2, there are
1 and 2 are the eyewitnesses. Trial court record. Well, just what is the name of the deceased?
What is the name of the deceased?
Name of the Prabhakar V.
Prabhakar
Bhue.
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 BHUE. So PW1 and PW2 are the eyewitnesses. And who is the doctor who conducted PM?
Dr. Miller.
Doctor, it is a peculiar case. The doctor who conducted the PM has never been examined in this case.
No, the PM report has not
PM
been.
report has been exhibited, my lord.
What is the number of the exhibit?
Exhibit
13,
13,
Exhibit 13 PM report also. Okay, come to the PW1.
Place, I know the parties to the case. I know the deceased Prabhakar Bhoi. The accused took the occurrence took place on 27/7/2011 at about 7:30 AM near a stream in our village Sardapali. I had been to this spot to attend call of nature. At that time, I found the deceased Prabhakar abusing the accused man. There was altercation between them. They were assaulting each other at the spot. Then the accused assaulted the deceased Prabhakar by means of a bhujali to his chest, left hand and a backside of head and neck. The victim sustained profuse bleeding injury on his person. I have seen the assault by the accused on the deceased on Rasiko Bhoi. One Rasiko Bhoi was also present at the spot.
PW2.
The PW2. The accused thereafter left the spot. Pradhananda Bhoi, the nephew of the deceased, immediately came to the spot.
He is PW6.
PW6, He and others shifted to the deceased to his house in injured condition and subsequently he died. This is the entire story.
Come to the PW2. Another eyewitness.
It is it's cyclostudy. He has submitted the same thing. I know the informant and the accused on this case. I also know the deceased Prabhakar Bhue. The occurrence took place on 27/7/2011 at about 7 AM near a stream in our village, Sardapali. The spot is locally called Balijharan. At that time, myself and PW1 were brushing our teeth. At that time, the deceased Prabhakar came to the spot and assaulted the accused by giving 2 blows by means of a bamboo stick. to the accused, my lord. They again fought with each other. I was standing at a distance of about 10 feet from them. Then accused assaulted the deceased by means of a bhujali to his chest,
left hand and back side.
and back side of the head and neck.
Doctor's evidence is see where are the injuries?
Exhibit 13.
Injuries.
That exhibit 13 is the list of exhibits also. Inside stab wound, first wound is a stab wound. Over the left side chest. Second is incised wound over the left arm. Third is also incised wound, occiput, also scapula. So there are 4 incised wounds, and the opinion is hemorrhage and sobs due to injury to the vital organs like heart.
Left side.
The aggressor was, you also may kindly consider, the aggressor was the deceased. He first assaulted. And while there is no strong motive also to kill him, he was just simply brushing his teeth besides a river, and suddenly the deceased started assaulting him.
That where from you got that bhujali with you?
That is the.
You are going to brush your teeth in a. So.
Why you are armed?
That part is completely silent.
If you would have picked up something from the spot,
from nearby something
different.
and attack them.
You are carrying a bhujali and with you and repeatedly dealing blows on the vital part of the body like chest, head, neck, and 4 injuries are there.
Carrying bhujali with you itself goes to suggest that there was some intention.
My lord, subject to your lordship's acceptance, my lord. So bhujali, whether was carried by me to the spot, it's never been proved by prosecution.
No. They have stated that you are having that bhujali and assaulted. So it was not with you. You picked up from somewhere. That is to be elicited in the cross-examination. Why the prosecution will say?
The case was conducted by SDC, your lordship.
That's a different matter.
SDC, only 2 to 3 cross-examination. Your lordship may kindly.
How many years he is in custody?
More than 14 years.
He was never released on bail.
No, my.
18th na kono?
Sanjay Mirza.
18/4/2012. 2012 ट्रायल कोर्ट रे बेल नथिला
ना
फॉरवर्डेड टू कोर्ट प्रोड्यूस्ड इन कोर्ट तो 2012 रे 13 वर्ष ହେଇଗଲାଣି आगुल बेल रिजेक्ट ହେଇନି जेसीआर
फॉर द फर्स्ट टाइम इट इज कमिंग मैडम
13 वर्ष ହେଲାଣି Are the learned counsel for the petitioner, learned counsel, amicus curiae, learned counsel for the state. From the records, it appears that the petitioner is in judicial custody for 13 years. Placing the evidence of PW2, the eyewitness to the occurrence, the learned amicus curiae submitted that it is the deceased who first started assaulting the appellant by means of a bamboo, and then the appellant retaliated and dealt some blows by means of a bhujali, and in such a scenario it is difficult to say that the ingredients of the offense under section 302 IPC are attracted, and there is absence of motive behind the commission of the crime, and therefore the petitioner has good chances of success. In the case, balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned counsel for the state placed the evidence of PW1, who is an eyewitness to the occurrence, and Exhibit 15, the postmortem report. 13, the postmortem report, which indicates that the cause of exhibit list that which indicates that the cause of death was on account of hemorrhage and shock due to the injury to the vital organ like heart. Considering the submission made by the learned counsel for the respective parties, the circumstances under which the crime has been committed, the nature of overtake attributed against the appellant the period of retention of the petitioner in judicial custody and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
But there was motive. PW5, if you see, the motive is there.
Yes, next.
To some extent.
Item 16.
16 is also, it is also a JCRL.
Yeah.
In this case, I have also been engaged to the legal aid.
Yes.
This is a case under section 302 and conviction is for life, my lord.
What is the judgment?
The judgment in the paper
302. Is it direct evidence or circumstantial?
Direct evidence.
With the eyewitness?
Eyewitness is the mother of the deceased and the father of the deceased is the present.
No, tell us the name of the deceased. Name of the deceased is?
My lord, Anam Korwa.
Anam?
ANAMAKARUA.
Anam Korwa, 3 years. Aged about 3 years.
3 years.
3 years.
What is the, who are the eyewitnesses?
The mother and the elder son of the
PW6 and 7.
PW6 and 7.
PW6 and PW7. They are the eyewitnesses. And who is the doctor who conducted PM?
PW8 in the
PW8.
8 is the doctor. What he has noticed, the doctor, lacerated wound on the occipital region, scalp, subcutaneous hematoma and internal injury, fracture of occipital bone with extradural hematoma. Cause of death was due to head injury. This is okay. Now we'll come to PW6. Let us see. PW6.
Yeah, please. I know the informant and the accused standing in the dock in my each my husband. We were staying in the rented house of Bela Lohar, PW4, at Azad Basti, Joda, on rent basis, along with our 2 minor sons, including the deceased. On the date of incident, there was quarrel between myself and my husband. My husband told me that my younger son was not belong to him by saying, "Ita mo chua nahi, quoted my, unquoted my, and then got hold of him, my younger son, and put forcibly on the ground, as a result of which my younger son sustained several bleeding injury on his head and died instantly. But I shifted him to Tisco Hospital where the doctor declared dead. So the informant lodged a report at the police station. Police came and held inquest over the dead body of my younger son, and I gave my LTA over the report. Out of grave and sudden provocation.
ये से जेल ले जो 500 করনো ଥିଲା से छुआ गुड़ा को से देबो किरो उठे कि नहीं उसी भले आ तो ये बापा ना तार छोटो छुआड़ा तार पड़ी कि नहीं ग्राउंड रे.
And the child witness is also there. PW7. He says that his father killed my younger brother.
Supported. But it is out of grave and sudden provocation. Instantly it has happened. And there was no intention to kill that small.
There was no provocation.
He suspected the paternity of the child. That was the reason why. And how many years he is in custody?
Around 8 years. I think the incident.
8 के 8 2016
9 years. No, sorry.
Put up this matter after summer vacation. Yes.
The anger issue, he has some anger issue.
And in the meantime, the London Council for the State shall obtain instruction about the status of the 2 eyewitnesses, that is PW6 and PW7, and also the criminal antecedent, if any, against the appellant. Yes.
Because if this anger issue is released on bail, he may harm the wife and
the custody certificate.
To place the matter.
Custody certificate anyway. PW6 or PW7 no status or criminal antecedent.
And jail conduct.
Conduct of the petitioner in jail.
Whether he has anger issue or not.
Yes.
Item 17.
17, Mr. Jafrullah.
The offense is under section 370C.
अच्छा आपनो ना उड़े आसीची engage करिया पाएं वो कार नाम फाइल कर दीजिए नहीं लेकिन prisoner's petition has been received, which is at flag C from District Jail, Keonjhar, regarding engagement of Mr. S.K.Sahoo as his advocate in place of Mr. C.R. The prayer is accepted. Mr. Sahoo has filed the wakalatnama. The name of Mr. Chittaranjan Sahu shall not be reflected in the cause list henceforth.
376 DA is the 6 box notice.
Notice जाइनी?
नहीं.
Since the petitioner has been found guilty under section kind judgment of part of the killer.
Running page
376D.
57.
376D and section 6 of the
376 DA.
Extra copy, the learning counsel for the state shall intimate the inspector in charge of which police station? Joda police station to serve a notice of the proceeding on the informant and is at liberty to engage any counsel of his choice to oppose the prayer for bail, and if he is unable to engage his counsel on his own, intimation shall be given to him that counsel from the High Court Legal Aid Committee can be engaged also on his behalf to oppose the bail application. And if he agrees for that, wakalatnama shall be collected and be sent to the learned counsel for the state. Free copy of the order be handed over to the learned counsel for the. Yes.
For stay, sir. IA for stay.
Asu. Yes, next. After summer vacation.
Item 18.
Notice has already.
Notice information. Offense कौन की?
Offense under section 376(2) and 376(3).
3
Item 19.
Item 19. My lord, today I am praying for the appellant custody certificate and antecedent.
All right. The learned counsel for the learned amicus curiae for the appellant submits that the learned counsel for the state may be asked to produce the custody certificate, so also to obtain instruction regarding criminal antecedent, if any, against the petitioner. Put up this matter after summer vacation, learned counsel for the state shall obtain such instructions. Yes.
Item 20.
Item 20 presentation of comments.
वकालतनामा फाइल कर दीजिए नहीं? अच्छा. Preview the prisoner's petition at flag D regarding engagement of Mr. Biswajit Naik in place of Mr. S.K. Sahoo. Mr. Naik has already filed wakalatnama. The prayer made in the prisoner's petition is accepted. The name of Mr. Suroj Kumar Rautrai will not be reflected in the cause list henceforth. Yes, Mr. Naik. Mr. Naik submit that since the paper book has already been prepared, the registry may be asked to supply him the paper book. You have received the paper book, and counsel for the state submits that he has received the copy of the paper book. Put up this matter after summer vacation. A copy of the paper book be supplied to the Mr. Naik in the meantime. और चीज़ दे दियो ना? हाँ दे दे. ना ये signature पे रखिए ना? ये.
Item 21.
Yes, Mrs. Das
I have engaged like a.
That is all right. But have you
Not received any judgment copy or also the prisoner question.
Srimati Meena Kumari Das, Land Counsel for the appellant is present, and she submits that she may be supplied with the prisoner's petition and impugn judgment. So also the deposition copies. Let the registry supply the same in our pen drive. Pen drive
To us also, pen drive.
And so also to the land council for the state. Pen drive achi. କାଠୁ ଆମଠୁ କାଠୁ ନେଇକି ନେଇଯାଆନ୍ତୁ ପେନ୍ ଡ୍ରାଇଭରେ ନେଇଯାଆନ୍ତୁ ଆଜି ଅଛି ତ ରେକର୍ଡଟା ପୁଣି ପଳେଇଲେ ଅସୁବିଧା ହେଲା and you go through it if you think that a bail application is to be filed you can file it okay after going through the judgment and the deposition copies which will be supplied to you in your pen drive if you want to file any bail application you can file it okay and it will come obviously after summer vacation yes.
Item 22.
In this case, my lord, State Council is directed to obtain
Yes,
the.
we have asked, we have sought for the instruction that has been intimated. He's from outside vendor.
Let me explain on here. I have committed a mistake on my part, personally. The address is correct, but the district is written wrongly. He is coming from the East Singhu, but I have written West Singhu. Not only in my appeal memo, it is in the since the inception. In the police report also it is written as the West Singhu.
No, you file the correct address in a with a memo so that
Now to correct.
no. You see that has already been scanned. So once you file, that would be better. You file a better an interim application to correct the cause title, and after it is allowed, you just file that one page, the first front page, so that it will be substituted here. Because it has been digitalized, so we cannot ask you to make, at that time it was permissible, but now you have to file this front page correcting, and that can be only done if a judicial order is passed, right? The Land Council for the has been wrongly mentioned in the cause title of the appeal memo, and she intends to file an interim application for correction of the district, and some time may be granted. Documentation, interim application for bail on the ground of wife's ailment. Medical documents have been filed. Copy has been served on the Land Council for the state to seek some time to obtain acceptance on the interim application. So also the authenticity of the medical document. Put up this matter after summer vacation. Yes.
Item 24.
24, Mr. Bhansdev. Next, it a count of the bail page. Next.
Item 25.
25 may clip for Friday.
Friday next week. You have received the deposition copies, etc.
Deposition copy I have annexed to the
Yes.
memo of appeal itself.
Put up this matter on 14th of May 2025. Yes.
Item 26.
Mr. Devasnan Das.
Both the matters, in 25, both the matters.
Yes, okay. 26, Mr. Devasnan Das is not there. Pass over from the next.
Item 27.
27, Mr. Budia. Not there. Pass over.
28.
After summer vacation.
Item 29.
And not on behalf of Mr. Amitabh Tripathi and praying for an
Playing for?
an action.
After vacation.
Item 30.
30, Mr. Raut.
Yes.
Last for the criminal antecedent.
Criminal antecedent. Yes, instruction. On Aslam. 9. Pass on provision. Again. गांधी दूध म्हणजे इथं खुल्लाळू 498A and 302. So the deceased was your wife. So he was staying with you, and it's a case of homicidal death. Counsel for the appellant submit that the appellant is having 3 children. The land and counsel for the state shall obtain instruction.
Item 31.
Mr.
Submit on behalf of Mr. Ellen.
Yes, yes.
This case, my lord. Conviction under section 3762L
4950 ର ବାହାର କଲ। ନାଇଁ 40 combination of delay ଗୁଡା ଅଛି 48 49 50 ବାକି ଗୁଡା କାଲି ନେଇ ଆସିବ 48 49 50 କାଲି। It will come tomorrow. You just go through and verify. What is the delay? 43 days.
27 come tomorrow.
Notice,
sorry, one notice has not been made sufficient.
Notice?
As in instruction.
अच्छा सीटा लिखी item number 27 है लिखो the Learning Council for the state took some more time to obtain instruction regarding service of notice on the informant. Put up this matter after summer vacation. 27.
36
Just a minute. Take down on item number 48. IA number so and so. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 43 days in filing this criminal appeal since the appellant has been sentenced to life imprisonment. We are inclined to condone the delay. According to delay is condoned, hard admit call for the trial court record and interim application for bail and stay realization of fine to be considered after receipt of the. Mr. Saran, you are there? From Denkana?
Yes, my lord, I am in DC.
Okay, we are condoning the delay and admitting your appeal and your bail application will be considered after receipt of the trial court record. You supply the deposition copies to the state council, right?
Yes.
Yes. Next.
Item 49.
49, there is delay. What is the delay? 128 days and it is a life imprisonment. Stamp report. अच्छा आज 75 दिन delay अच्छे है ना 75 days delay to be condoned है ना admit कर दिया धीरे अन्य applications गुड़ा अच्छी interim application for bail and stay realization of fine to be considered after receipt of the trial court report deposition copy to be supplied है ना खाली नहीं इसमें सब गुड़ा
May I be pardoned, my lord? My lord, item 42, my lord, the display board was not working, my lord, and we somehow missed the item, my lord. I'm extremely sorry, my lord.
It will come tomorrow, madam. It will come tomorrow.
My lord, my lord, my lord. Highly obliged.
Bench also answer.